Or my lord, any forum under the provision of Electricity Act.
That is for you to decide.
My lord.
I'm grateful, Lordship. I'm not. making
Learned
any
counsel for the
submission,
petitioner seeks to withdraw the present writ petition to take appropriate remedies in accordance with law. Dismissed as not passed.
Grateful, Lordship. Grateful, Lordship.
Dismissed as not pressed.
As not pressed, sir.
My lord, I have not any submission for not pressing the writ petition.
Come, I'll dismiss the case.
My lord, one thing, my lord. My lord,
I'll dismiss the petition, sir.
my lord,
Mr. Naik, where is?
my lord, no date. Since my lord desire.
That's
my
why I said you will take your remedies in accordance with law.
my lord,
And
no,
you're not pressing this writ
no
petition.
further order is required, my lord. If there been observation, no further order is required. I'm grateful to all.
Grateful, Lordship.
I said that.
I'm grateful to all.
Dismissed as not pressed. I'm not expressing
I'm
any
grateful.
opinion.
Item 37.
37, my lord, I am for the petitioner, my lord.
I am for the response.
My lord, the dispute is regarding, my lord, using the petitioner's, my lord, land to install, my lord, a high voltage 11 kV, my lord, electric line. That is what, my lord, the dispute has cropped up. Now, my lord, already, my lord, it has been installed. Now, my lord, the petitioner has made an application, my lord, for shifting of that. Now, my lord, primarily, my lord, inspection, my lord, they say inspection was done. My lord, the petitioner says, my lord, inspection was never done, my lord, with a notice on me. Proper inspection was never conducted. Now, my lord, my humble submission before your lordship would be, my lord, that, my lord, according to, my lord, the works of licensee rules, my lord, let this be relegated, my lord, to the district magistrate, my lord, to, my lord, take a decision, my lord, on the whether, my lord, at all, my lord, it is feasible, my lord, to shift, my lord, the line, and whether, my lord, if shifting is, my lord, at all possible, what should be the quantum? Because, my lord, they have assessed a quantum which, according to the petitioner, is extremely high, my lord, unjustified.
Yes.
My lord, your lordships kindly come to paragraph 5 and 6 at page 3. First, my lord. Paragraph 5, in his representation, he himself says that yes, I will provide the land, kindly do the needful. Paragraph 6, he says that yes, I willing to pay the cost, kindly do the needful. Now, my lord, your lordships kindly come to page 12. Kindly come to page 12. Second paragraph. After due consultation with you, our technical team had scheduled 3 consecutive occasions for inspection at your desired premises. This was done in view of ensuring mutual cooperations and minimizations of any inconvenience that may arise during the process. Regrettably, despite our collaborative efforts, you were absent at your location on each occasions. Now my learned friend says, my lord, that we have not done. 3 consecutive days, our technical persons, my lord, had been to the premises for making inspection. He didn't cooperate.
This is what the letter says, my lord. My
Yes.
reply says otherwise.
Yes.
My reply says you have
My lord,
never come.
my lord,
You have
from-
never, my lord, properly,
from-
my lord,
my
given.
lord,
You had your chance.
Yes, my lord.
It's not a cricket match.
No, my lord. Sorry, apologies.
Now, my lord, we have issued quotation at page 10, my lord, on 31st January 24. That is valid for 90 days. That has not been deposited. My lord, your lordship knows, my lord, as per my lord electricity rules 2005, if anybody, my lord, dispute the cost, he can approach the electrical inspector. That is the, my lord, law is there. Now, my lord, my instruction is, we have, since this quotation is for 90 days and that was expired, my lord, further estimate was done and that was sent for approval, but my Lordship has to cooperate with us. Because high tension line, your Lordship knows, my Lordship, a matter of right to, my Lord, shift. For their convenience, sometimes, my Lord, it is our responsibility to shift. Yes, we can. But had it been a case, my Lord, is there any lapses on our part? We have estimated, we have sent quotation, they have not deposited. Now, my Lord, the further quotation will have to raise because 90 days is already over. And the cost may be, my Lord, for escalation and etc. maybe. And my Lord, if my Lord is agree, we can approach the Chief Electrical Inspector. That is the law. And he himself, my Lord, says that, yes, I am ready to provide the land, I am ready to pay the cost. Thereafter, my Lord didn't take any steps, didn't cooperate and file a writ petition.
Are you ready to make the payment?
My lord, the difficulty is, my lord, the petitioner, my lord, my specific allegation is, my lord, the payment that, my lord, the quotation that they have made, my lord, is exorbitantly high, my lord, with regard to, and my lord, there is, my lord, absolutely other space available. My lord, the all dispute, my lord, they have, my lord, initially installed the line. They have, my lord, made the quotation. They have, my lord, allegedly, my lord, made the inspection. With the petitioner, my lord, nowhere in the picture, my lord. Kindly, my lord, refers it, my lord, to a, my lord, my lord, a neutral body might be, my lord, referred to, my lord. Kindly considers, my lord, the works of licensee rules, my lord. The district magistrate, my lord, let it be, my lord, referred to him, a decision be taken. If, my lord, the
Take a
district magistrate,
decision.
my lord,
It is not a case of district
Can't take a
works for
decision on
licenses
shifting
rules.
of,
Yes.
my lord, kindly considers, my lord, otherwise, my lord, it's being unilaterally, my lord, being given. The quotation, the inspection, my lord, their allegation, everything is, my lord, has been unilateral.
Well, that is the law.
The
How
petitioner
quoted-
is aggrieved by inaction on part of the respondent authorities in shifting, in not shifting 11 kV line running from, this is running in your, from the top of your house, what is it?
Yes, yes, yes.
No.
And my lord kindly considers
Not how.
Running through petitioner's property.
petitioner's land, my lord, land.
Land, not
Running-
house.
Running through petitioner's
But
land.
extremely close to the house, my lord.
Running through petitioner's land, full stop. Learned counsel for the petitioner submits that in the year 2020, the respondent authorities had installed a 11 kV voltage electric line, and the same was carried over the petitioner's premises, petitioner's land, full stop. The petitioner had made a request, a representation before the authority for shifting of the said line. In terms of such said representation, the petitioner, the respondent authority had sent a quotation for an amount of rupees 2,12,865 to the petitioner, full stop. The petitioner had protested against the said such huge against such huge quotation, such a huge amount in the quotation. Thereafter, on which page is that inspection? Thereafter,
Yes.
the respondent authority on 18/3/2024, after due consultation with the petitioner as well as the technical team, had scheduled 3 consecutive inspections on petitioner's premises. But on all the occasions, the petitioner had not cooperated in the joint inspection. It was noted by the respondent authority that the unexpected absence on part of the petitioner had led to substantial wastage of time and had impacted the at a substantial amount of time, full stop. full stop. The said fact is disputed by the petitioner. Learned counsel for the respondent seeks 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 6 weeks.
I'm grateful to you.
Grateful.
Yeah, affidavit is taken on record.
Item number 43. In this matter, I am appearing on behalf of the writ petitioner. This is that matter where there was suppression of fact.
Lordship,
Draw. What do you want to do?
Withdraw.
Learned counsel for the petitioner wishes to withdraw the presented petition. The same is dismissed as withdrawn. Who's the advocate on record?
I am, my lord.
Don't do that.
No, for
Lordship,
the
I-
first,
Don't open your mouth. It's better for you. You want adverse remarks? I'll do that. I'll impose cost on you for suppression of fact, misleading the court. All right.
Item 47.
my lord, I beg to you on behalf of petitioner. Well, in this case, what is when I want fact? Well, petitioner is the, my lord, is the son of the private respondent here. Private respondent meter my lord, in the ground floor with the lock and key. My meter is outside of the premises. I am residing in the first floor. But since my lord, my grandfather had gifted the property to me, my lord, conspiracy started by the private respondent.
Final assessment order, sir. Why?
Well,
are
I'm
you-
coming, no, not that. Mane, without notice under section 135(3), inspection has been made. And my lord, here in kindly see provisional assessment, why the provisional assessment? bad?
You are here against the final assessment order.
No. My lord, kindly see provisional assessment. Why provisional assessment is bad? Kindly see, my lord, page 23,
Page 20. Yes.
page 23. But here in this case, the assessment has been made. My lord, in the, my lord, middle portion, being authorized assessing officer WBCDCL have no designated by the state government. I do hereby issue order the provisional assessment under section 120 of the Electricity Act 2003 as amended up to date as guided under article 5.1 of the regulation number 36 such and such dated 12/9/2007. I do hereby assess the payable amount of the provisional assessment bill and such amount. Malad, these malad calculation has made
Read further.
Malad,
time.
I will such and such center within cash collection hours within 5/11/2003 in 24. In case the bill amount such and such 2 lakh or more only demand draft or bank card check in favor of WCDCL shall be accepted as payment. However, accused entitled file objection if any against the order of the provisional assessment before the assessing officer within 4/1/2024 and such malad calculation is there.
Sir,
Malad,
sir, wait a minute. Read again. However, the accused is entitled to file objection, if any, against the order of provisional assessment before the assessing officer within 4/11/2024. Did you do that?
malad, since
Sir, can you
malad,
please,
kindly malad,
can you
kindly.
please answer
They
question?
repeal that with the calculation under the repeal malad provision regulation.
Did you file your objection?
Yes.
Where is that objection which you have filed, sir?
Huh? No, ita na. Malad, basic malad. I'm really confused malad in this matter. Malad, page 27. Like here I have stated already been repealed. Paragraph 1, page 27, paragraph 1. New regulation has come.
After this, they have passed
The
a
new regulation has
Kindly come to page 40, final order of assessment.
come into force, my lord, page 43. The regulation has mentioned, my lord, I'm saying in excess of the power conferred on subsection 1 of clause X, subsection 2 of section 181.
What is the new regulation?
But regulation, I tell you, Lordship, that there is a wrong implication of this provision. You know, Lordship knows it is a well-settled proposition. Implementing wrong provision is not a fatal. There is a specific thing. The
But
regulation is
calculation on the
55.
basis of-
Regulation is 55. It is a perimetry provisions under section 126 of the Electricity Act. There is a specific provisions for provisional assessment, and that has been granted. And regulation is the regulatory regulations, and on the basis of the regulation, now new regulation is 55. That regulation is 55, which is instead and place of that regulation, this 55 has come. Now at this stage, final order of assessment has already been passed, and my humble submission before Lordship, he has filed this writ petition within the limitation period. He has got the, now he has got the, I will say, right to ventilate his grievance before.
Mr. Saab, if your notice itself is prima facie wrong, and
But
under
section
the-
under 126 notice has been granted.
if it was supposed to be under 55, was it supposed to be under 55?
No,
That
no,
is the law.
Page
no, no, no,
43.
no. Lordship, kindly
Page
see
43
section
regulation.
126 of the
That
Electricity
is
Act.
repealed,
Yes,
page 43,
which relevant section?
my lord, section, my lord, here in this case, my lord, at the my lord, third column, in supersession of notification number 36, WERC dated 12/9/2007, published on 12th September 2007. On that, it also, my lord, withdrawn, repealed.
My notice has been given under section 126 of the Electricity Act.
But under
Kindly see
new
the
regulation,
Electricity Act.
Under the
Yes. Won't confuse. Just a minute. Make your submission. What are you saying? Say it again.
my lord, let him submit, my lord. I'm
No, you can make your submission. Tell me what are you saying? I'm not able to follow you, sir. What are you saying?
my lord, when the calculation, my lord, on the basis of the old regulation,
When was the calculation made? Which year?
my lord, calculate on the 126. My lord, procedure, page 60 of the regulation.
Mr. Saha, can you help me?
Ma, kindly come to section 126 of the Electricity Act.
No, first tell me what is the submission which is making.
Page
Sir.
60.
Page
60. 5.1.
regulation. But the calculation which has been made under regulation 5.1, that is under regulation 55, clause 5.1. But the actual parent act is section 126 of the Electricity Act. Notice has been given not under regulation 5.1, Lordship. Notice has been granted under section 126 of the Electricity Act, which is the statutory act. Regulation follows the act. Now, the act provides itself to give the provisional assessment under section 120. Kindly see 126 for a moment. Babu, বইটা আপনি দাঁড়ান। একটু দাঁড়ান। But this notice has been issued under section 126. So far, the conduct is concerned, it is provided under section 126 of the Electricity Act, which is very much crystal clear, where the provisional assessment has been made under section 126 to the best of the judgment of the assessing officer. And on that basis, notice has been granted, opportunity has been granted. He has availed this opportunity, and on that basis, under section 126(4), final order of assessment has been made. And under section 127, it has been provided that he could have preferred an appeal, before the appellate authority within a period of 30 days. Now, admitted fact that this final assessment has been passed on 18 December 2024. And he has filed this writ petition taken away within December 2024. That is within a period of 30 days. Now he can ventilate his grievance before the appellate authority.
Yes.
Regulation is the mere regulation to grant the formula.
My
Sir,
lord.
read 126.
Yes.
My lord,
You read 126.
But that-
Your allegation is, or your submission is, that they have wrongly assessed you under section 126. They should have done it under regulation 55, right? Rule 51. That is what he's saying. If I understand
Lordship,
correctly, that is
Lordship,
your argument. They are empowered to pass a provisional assessment order
Under
under
section, they cannot. Page 60, kindly see what they have stated. Provisional assessment under section 1 of section 126 of the Act shall be made as per the following method.
Yes.
But the method is one of A, B, C, D, everything is there. Page 60, 61,
Yes.
62, everything is there.
Yes.
But in the provisional bill,
Yes.
they have mentioned the old regulation, which is not at all withdrawn by the commission. But it is binding.
So challenge it before
Yes.
the appellate authority.
Who has stopped him?
Challenge it before appellate authority.
My lord, because I have not filed an appeal, because of the reason I challenge this assessment order,
Yes.
because they have violated the provision of the regulation. But second submission, my lord, here in this case, my lord, only I pray. What I deliver, all right, my lord, in this aspect, my lord, that is end. What, my lord, the person, my father, my lord, who has, my lord, whose meter inside of the first floor, my lord, he was present and he originated theft and tapping. From the allegation is the tapping of the electricity from his meter. What here from the station manager, since he is a relative of the private respondent, my lord, already restored the electric connection without sending the meter to the forensic laboratory. Without sending, but they have destroyed entire evidence. Without serving any meter, but they cannot restore. So, my lord, I made the complaint before the officer in
Sir,
charge.
all this can be alleged before the appellate authority also.
Well, the
There
appellate
is-
authority is without authority is that criminal consequences.
Criminal consequences
What a crime,
are under 135. You handle your criminal consequences under 135. As far as 126 is concerned, it is looking into your civil liabilities. Your criminal liabilities are under 135, where there's a separate proceeding which is taking place. So you don't have to worry about this.
Well, how this was within the
You challenge it during the course of your criminal proceeding.
restore the electricity of the private respondent.
You challenge that, sir. You challenge it. You
So,
challenge it.
my lord, station manager disconnected my supply. But
Sir, you challenge it. You are at liberty to challenge it.
Both the person, private respondent and petitioner are guilty. But his line has been restored. When the allegation is, I have tampered the meter from his meter. Is tapping from his meter.
Take down. The petition, the present writ petition is challenging the provisional order dated 22/10/2024 and the final assessment order, provisional assessment order dated 22/10/2024 and final assessment order dated 4/12/2024 passed by the respondent authorities under section 126 of the Electricity Act 2003. Learned counsel for the respondent at the outset submits that the final assessment order is appealable before the appellate authority under section 127. 127 2.
127.
127. Full stop. This court has heard the argument of both the parties and have examined the records. The petitioner is aggrieved by the provisional assessment order as well as the final assessment order dated 4/12/2024 passed by the respondent authority under section 126 of the Electricity Act, and the same is appealable under section 127 before the appellate authority. Since the petitioner is having an alternate efficacious remedy available under the Act, this court is not inclined to exercise its discretionary relief under section 226 of the Constitution. In view of the same, the present writ petition is dismissed with liberty to the petitioner to avail his statutory remedies available under the Act.
Right, one intelligence, my lord. Kindly mention, my lord, I have also already challenged the provisional assessment and the annual assessment under the old regulation. Kindly mention.
The ऊपर लिख लेना. The
Only one is there.
petitioner submits that the petitioner has challenged the assessment orders on the ground that the same has been raised under the old regulation, which has been annulled. Petitioner submission ऊपर डालो.
Deeply open. Item number 50.
I appear for the petitioner. Matter, my lord. My husband was the original owner. I got the property from my husband. My husband died. I applied.
Yes.
My lord, I applied for domestic electricity connection. Now, my lord, everything completed. My lord, they have erected electric pole, but due to objection by the private respondent, that this connection has not been still given. But only objection with regard to the fact that the electricity line will be drawn by over a common passage. The common passage, I am also the owner. Now, my lord, this is the page 35 is their intimation.
Page 35.
Page 35. They are also, my lord, have done everything, but due to objection of the private respondent, they could not supply.
Yes, Mr. Mukherjee.
I seek for police protection and for execution of the
Yes.
work, my lord. My lord, we have tried, my lord. My lord, firstly, we have tried on 20th of
I'll
May.
give direction.
My lord.
I'll give direction for police protection. It can be granted, right?
Yes, and we have to erect, my lord, some poles, my lord. Let that also be recorded in the order, my lord. For erection of poles, police protection is given for
You
erection of.
see, erection of pole has been done.
No.
Page 35. Erection of pole has been done.
Yes, only
Election of pole has been completed.
completed.
That's your statement. Okay, done. The petitioner is aggrieved by non-grant of electricity connection for his residential premises. It is the case of the petitioner that her deceased husband had purchased plot number 94 in jail number 73, Mauza, Begumpur, under Begumpur Gram Panchayat, Police Station, Chanditola, District Hubli, wide, registered conveyance deed bearing number I-1651/2016, full stop. After the death of her husband, the petitioner became the owner of the said property, full stop. She applied for a residential electricity connection on 4/4/2024, full stop. The respondent authority had raised the quotation, which has been duly paid by the you have paid it, right?
Yes, I have
Which
paid.
has
my
been duly paid by the petitioner. It is the submission of the petitioner that the service lane through which the connection had to be effected is a common passage, and that the respondent number 4 is wrongly alleging himself to be the absolute owner of the said common passage. That's right?
No, they are objecting because they have also their share. That is a common passage.
Okay. Just take down it. वो change कर दो. It is a summation that the service lane has to be drawn through a common passage, and the respondent number 4 is objecting to the same. Okay. Line change kar. Is objecting to the same. Full stop. Learned counsel for the respondent WBCDL submits that they had already issued the letter of intent for installation in favor of MS Genuine Electrical, and the erection of pole has already been completed. Full stop. However, due to objections raised by respondent number 4, they could not complete the work. Full stop. The learned counsel for the respondent authority submits that they are ready and willing to install the electricity connection, provided they are given adequate police protection to carry out the installation work. Full stop. Anybody appearing for respondent 4? No. This court has heard the argument advanced by the parties and have produced the documents on record. Full stop. The petitioner is entitled to get a domestic electricity connection subject to fulfilling all the necessary formalities as required by the respondent authorities. Full stop. In the present case, the petitioner has complied with all the required formalities, and hence it is her right to have an electricity connection. Full stop. In view of the statement made by the learned counsel for the respondent authorities that they are ready and willing to grant an electricity connection to the petitioner subject to availability of adequate police protection, this court deems it appropriate to direct who?
My lord, official in charge, my lord, Singur police station. This is respondent number 3.
See Singur police station to provide police protection to respondent WBCTL in carrying out the necessary installation work as well as in granting electricity connection to the petitioner. Full stop. With the above direction, the cost of the same shall be borne by the petitioner.
My
With the above direction, the present writ petition is disposed of.
lord, kindly specify a time within which, my lord, such connection can be, my lord, drawn.
3 weeks, my lord.
वहाँ जाए ना, is ready and willing to grant electricity connection within a period of
3 weeks.
3 weeks.
Grateful.
Item 52.
My lord, this is my application, my lord. My lord, I've served to the party. I'm this is my affidavit of service.
আমি আছি আমি আহ,
My lord,
Yes.
my lord, I'm seeking my lord's kind intervention, my lord, for direction upon the distribution company, my lord, to install my meter. I have already paid, my lord, but the security, my lord, deposit as well as the other requisite charges, my lord, long back. I have also, my lord, verbally, my lord, we have also met, my lord, to the my lord, authority concerned, my lord, up till now, my lord, they have not installed. At last, my lord, if your lordship kind of takes, my lord, page 24, annexure P4, my lord, this is my representation to the manager, West Bengal State Electricity Distribution Company Limited, my lord, Shaktipur, Berhampur. Your lordship kindly says, my lord, I've written that request for installation of new electricity connection for commercial use. My client, my lord, have sent. I hope this letter finds you well. I'm writing to bring to your attention the issue regarding the installation of a new electricity connection for my property, for which I have already paid the earnest money and the required security deposit as per the procedure. Despite this, there has been no action taken to provide the electricity connection or install the new meter or to date. In the meantime, my client has also made repeated attempts verbally because my client was suffering from heart disease, lost her wife in COVID pandemic, was fighting case for her daughter and could not give his attention in harvesting, and to yield crops, my client had to obtain the electricity connection. However, despite the payment of the security deposit in the year 2015, the connection has still not been provided, thereby causing significant hardship. Due to this delay, I am unable to proceed with my commercial activities, including the cultivation and the harvest of the
May I,
crops.
sub-
This is the
May I submit? He has applied for the new service connection of the STW connection. We have made an inspections and we have found that it requires a huge cost of almost 10 lakhs. Now we have already, due to economically it is not feasible, we have already intimated to the petitioner that it has been duly received by the representative of the petitioner.
representative of the petitioner. I have applied.
Now here, now your lordship kindly see the next thing, that is that there is a specific office order. এটা একটু দিন।
My lord, I have not received.
না,
my lord.
office order, office order,
I have not received anything.
where it has been specified that the authority can incur the expenditure up to 75,000 per kVA, and here it requires of 5 kVA, and 5 kVA requires 3 lakh or almost 4 lakhs, near about 4 lakhs it requires. But the cost required, where after due inspection we have found it requires 10 lakhs rupees. So at this juncture, so it is not technically feasible. The entire cost is to be borne by the petitioner. But this is the precarious
My lord,
situation.
this is the
Lordship.
first time, my lord, we are hearing this, my lord.
Give him a copy of this letter.
Yes, certainly.
You take instruction,
I have to take instruction and all that, my lord, I have to come back.
not today. Learned counsel for the
Any other?
ऐसे कर लो फिर ये the petitioner is aggrieved by non-grant of electricity connection by the respondent authority to carry out his agricultural activities. Full stop. It is the case of the petitioner that he is the owner of agricultural land being Dag number 12, JL number 94, Moza, Paltipara. Full stop. The petitioner had applied for an electricity connection and had deposited the requisite amount by receipt dated 21/12/2015. However, no electricity connection had been provided to him. Being aggrieved by the same, he had made a representation dated 25. You decide his representation?
Yes,
and
that
direct
can
them?
be also
My
be
lord,
done.
25th of November, 2000, my lord.
But that can also be done.
They'll decide your representation. He had submitted a representation dated 25/11/2024. Full stop. Learned counsel for the respondent WBCDL submits that they shall decide the petitioner's representation dated 25/11/2024 within a period of
I just leave up to lordship.
3 weeks.
3 weeks.
Within a period of 3 weeks after.
But lordship, kindly, my lord, keep the matter alive, my lord.
Why will I keep the matter
My
alive?
lord, my lord, unless, my lord, they will again, my lord, because they are sitting tight over the matter, my lord, for the last, my lord, 9 years, my lord. Now they are saying, my lord,
Why
cost
have
has
you
been-
come after 9 years? You
No, my
should
lord, I
come
have
earlier.
already, my lord, in touch, my lord, I have already deposited in the year 15.
Then let me use my affidavit, lordship. Then let me use my affidavit.
You want to?
No, I
Let me
want,
use my
my
affidavit.
my lord, I want consideration, my lord.
No need for consideration. You keep it pending. That's
I
why
I
I'm
will file my
asking.
affidavit.
Yes, my lord, then your lordship, my lord, whatever lordship things meet and proper lordship can passes the order.
Yeah, like what?
The cost has been enhanced and all that.
3 weeks after affording an opportunity of hearing to the petitioner as well as all interested parties. Full stop. In view of the statement made by the learned counsel for the respondent, this court deems it appropriate to dispose of the present writ petition with a direction to the respondent authorities to decide petitioner's representation dated 25/11/2024 within 3 weeks from the date of communication of this order. Full stop. With the above direction, the presented petition.
But it should be concerned station manager, only manager it has been written.
Concerned,
Station man.
grateful.
May I take back this?
Yes, yes, you can take that.
We do. And deeply.
उसमें एक line add कर देना ऊपर. Learned counsel of the petitioner
But
Agrees
since no
to the
affidavit has been taken out, all allegation made then.
said statement by the respondent and states that he shall be satisfied if his representation is decided in a time bound manner. उसके बाद वो direction डाल. Good.
Item 53.
I am for CC here.
My lord, I am for the petitioner, my lord. On several occasions, I tried to contact with my clients, but he is not, I'm unable to contact him. So I have intimated a letter also to him. So my lord, kindly deal with the matter because he is not contacting with me.
The last occasion also no one.
Learned counsel for the petitioner states that she is unable to establish contact with her client. She does not wish to represent the client any longer in the presented petition. Full stop. There is no appearance on behalf of the client. There's no personal appearance on behalf of the petition person. Even on the earlier occasion, there was no. इसको छोड़ दो. It seems the petitioner is not interested in pursuing the presented petition. The same is dismissed in default.
Item 60.
My lord, I appeal for the petitioner, my lord.
And I appeal for the respondent number 5 and 6 housing board.
My lord,
I'll come back after 5 minutes. I'll come back
I am for
after
the state.
5 and 6. Yes.
Item
Malad,
60.
Malad,
for the
my
statement.
petition, Malad. Malad, this is my petition against an illegal and unauthorized construction being carried out in my property without my consent or knowledge, Malad. Malad, the petition number 1 and 2 are siblings. They own 2/3 portion of a property. That property initially, Malad, belonged to the West Bengal Housing Board. That was granted by way of a 999 years lease to the petitioner's mother. After the intestate date of the mother, my lord, the property, which is as of now a 2-storied building, was jointly inherited by the petitioner number 1, 2, and the respondent number 8. All three are siblings, my lord. My lord, the petitioner number 1 and 2, by dint of their work, they reside outside Calcutta, my lord. The property is in the occupation of the respondent number 8. Now, what the respondent number 8 had done, my lord, initially they tried to utilize the rooms in the ground floor and tried to open an animal creche. We had objected to that. But since we were living outside, we could not follow up. My lord, in July 2024, my lord, we came to know that they are constructing an additional 3rd floor in the top of the 2-storied building. My lord, they had already broken down a concrete water tank and they have proceeded substantially in the construction. If Malad will kindly take one look at page 55, Malad, at the image, Malad, that will make things very clear. Malad will see, find this is a 2-storied building, and on the top of that, they are in the middle of a construction. Malad, the petition number 1 and 2 are the joint owners along with the respondent number 8. No permission has been taken from them. No NOC has been granted. They are not even aware of what is happening. Malad, without the permission of the majority owners, Malad, how can a construction be made? How can a plan even be applied for sanction, Malad? Malad, I have written multiple demand justices, to the municipal corporation as well as the police. Nothing has happened. So I had filed an RTI to the municipal authorities asking, did you sanction a plan for this area? Malad, will find the RTA at page 52, Malad. I asked, did you sanction and plan for this building? Did you alter the municipal assessment records? Did you give permission for an animal creche to operate in a residential building? Till date, Malad, there is no reply to the RTI. Malad, this is a completely unauthorized construction. This could not have taken place because I am 2/3 owner. No NOC has been taken from me, no permission granted.
Yes, who do you appear for?
Well, I'm for the state, my lord.
Who's for the municipality?
Nobody's appearing.
My lord, a lady was appearing before my lord rose for recess. We had served them pursuant to my lord's direction.
Who was appearing?
Number? Mr. Vijay Agarwal, and we have also served Ms. Shreyashri Chaudhuri.
Vijay Agarwal, I'm for the state, my lord.
You are Mr. Vijay Agarwal?
Yeah, my lord. Yes,
My lord, I believe Mr. Chaudhuri was appearing before my lord rose for the recess.
same for the state, my lord.
Shreyashri Chaudhuri.
Both are from the state, my lord. Need to serve.
My lord, we have all served.
Need to serve a copy to the municipality. They are not served. They have not served any copy to them.
Affidavit service?
File
We have
affidavit
filed the
service.
affidavit service, my lord. Municipal state. अरे बाबा.
My lord, he is for the municipality.
Yes, madam.
My lord, the petitioner made a complaint on 9 January, my lord. On the basis of that, my lord, the municipality has caused an inspection on 6 March, my lord. My lord, I'm submitting the inspection report. My lord, at the time of inspection, my lord, both the petitioner and the private respondent, my lord, they could not produce any documents, my lord.
But take action.
Yes, my lord.
Take action if the
As well,
property
Lordship.
is.
My lord, let the representation be considered by the chairman, my lord.
My lord, we have, may I just say, my lord, we have been sending representations since November 2024.
What do you want? Do you want
Well,
the
it's a-
representation to be decided? You want a date for 2 months?
My lord, I would pray for a order of demolition. My lord, they have
Of
admitted.
demolition, I will not pass unless until I take affidavit in opposition. Can I
my lord, then,
pass?
my lord, then consider, will kindly direct them to consider my representation, but within a time frame, if my lord would kindly
That's what
give
I'm
them.
asking you. What do you want? You want them to file affidavit in opposition and take 6 weeks, or you want your representation to be decided?
Representation decided, but my lord will kindly fix them a time frame. That is my only humble prayer, my lord.
The petitioner has referred the present writ petition alleging unauthorized construction by respondent number 8
Yes, my lord.
over the roof of premises number P/134/ Kalandi Housing, Calcutta.
My lord, I'm sorry to interject, my lord. My lord, I also prefer stay of further constructions till the representation is considered, my lord. Otherwise, they are going ahead with the construction at extreme haste. My lord has seen the picture, my lord. Even 2 months back, my lord, all the walls have come.
It is the case of the
But my lord, let them not carry out. If since they have held that
it
there
is
is no
the case of the
documentation, let them not
petitioner
carry it
that
out.
they
my
are
lord.
the co-owners of the property in question, along with respondent number 8. Full stop. The said property is having a ground floor, first floor, and second floor. Full stop. However, the respondent number 8 is constructing an additional floor without the consent of the co-owners and also without having necessary approval / sanction from the sanction plan from the respondent corporation. Respondent municipality, South Dum Dum municipality. Hence, the petitioner had approached the respondent Dum Dum municipality wide representation dated 9/1/2025. However, the respondent municipality had failed to take any action.
My lord, I had filed 4 demand representations, last of which is 9th January.
There were several representation, lastly on 9/1/2025. However, the respondent have failed to take any action or respond to his representation. Being aggrieved by the said inaction, the petitioner has preferred the present writ petition. Full stop. Learned counsel for the respondent municipality, Miss
Moushumi Bhawan.
Moshmi Bhavani, submits that they have received complaint dated 9/1/2025 and had carried out an inspection on 6/3/2025, wherein it has been observed that ongoing construction above the 2-storied building is being carried out. She further submits that no supporting document in terms of the sanctioned building plan has been handed over to the respondent municipality. Full stop. Counsel for the respondent municipality further submits that they are ready and willing to decide petitioner's representation dated 9/1/2025 in a time-bound manner, preferably within a period of 4 weeks after affording 4 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as all the other interested parties. Full stop. In view of the said submission, learned counsel for the petitioner submits that he submits that he'll be satisfied if his representation is decided as per the statement made by the learned counsel for the respondent municipality. Full stop. In view of this court deems it appropriate to direct the respondent municipality to decide petitioner's representation dated 19, what is the date? 19?
9th January.
9th January 2025. Within 4 weeks after affording an opportunity of personal hearing to the petitioner as well as other interested parties by way of a speaking order. Needless to mention, the petitioner shall be at liberty to challenge the said order if aggrieved by the said order. Needless to mention, if aggrieved by the said order, the petitioner shall be at liberty to challenge the same in accordance with law. The above direction, the present petition is disposed.
But
Well,
will
the inspection report will
this is steps to issue a stop work notice. Otherwise, the construction is going to at full swing, my lord.
It is further directed that till the time the representation is not decided, there shall be a stay on the construction. For a period of stay on the construction till the speaking order is passed.
My lord, a copy of the inspection report be circulated, my lord.
My lord, at the time of inspection, my lord, your lordship kindly observe, at the time of inspection, both the petitioner and the private respondent, they could not produce any documents.
I have recorded that.
Grateful, my lord.
Grateful, madam.
61.
My lord. I'm appealing for the petition. I am opposing
My lord, I'm appearing
For the-
for
Yes, Mr. Chaudhary.
For the private respondent, this is not a extremely distasteful state of affairs. Two
You are
learned
for?
for the private respondent, Fox and this Fox and
Let-
Mandal, the solicitor firm, partners of the old firm, against each other, taking it to a different level. This is most unfortunate.
They have done it before also.
Yes, yes. Your lordship knows, this has been
They're in the
going on.
habit. Litigation in different courts.
Yes. So, the firm split. The split, was amicable. Now,
I'm not aware of what has happened here.
Yes.
I know that there was a litigation going on in Delhi High Court.
yes, Delhi High Court here, that is between the petitioner here and the other brothers. The petitioner is the center of all litigation. Now he files a petition saying that at their ancestral home
This is my
there is a lift
petition.
being put, which is totally false.
Who's the petitioner?
No, no, I'm appealing for the petition.
Yes.
My lord, pursuant to my lord's earlier direction, we have put
Wait a
them.
minute, wait a minute.
Yes.
Who's the petitioner?
No, no, I'm appealing for the petition.
No, who's
Not
the
before
petitioner?
this
Shom Mandal.
Not before this court. Let this matter be listed before another bench, subject
Personal
to
law.
orders of the Honorable Chief Justice.
In fact,
But then the service
was
may be taken
hoping-
back.
I was hoping your lordship would
Mr. Chaudhary, I started my career for a week working in Foxman.
it will not make
So
no
I will
difference
not-
to us.
I will not hear this petition.
In that case, may I request my learned friend to ask his clients to come so that we can sort this out
I will not hear this.
before your
petition.
lordship.
Mr. Chaudhary, take it somewhere else. Take it somewhere. It's not appropriate.
I understand. Well, that was a time when the firm was doing really well in Delhi.
Yes, one doctor's lane. Unfortunately, I worked only for a week, but still I did.
Much obliged.
62.
62. In this matter, I am for the petitioner. This is matter against non-consideration of representation by the administrator for the municipality, and it is pending for a long time. Allegation is that, my lord, the private respondent number 9 to 14, they are going to construct their house.
Who's
upon
there
the-
for the state?
I have served copy upon all the respondents, my behalf. On the earlier occasion, my lord, your lordship directed me to serve copy upon the learned GP. But I went there, they have not received it.
How can they not
Unless your
receive it,
lordship,
sir?
my lord,
How will they not receive it? What can, he's appearing for the, Mr. Agarwal? You appear for the state?
Hello.
What is he saying? Not received and all. Take instruction.
My lord.
We'll keep it after few days. You take instruction, Mr. Agarwal.
My lord.
next to them.
Two.
अपना नाम पे
Vijay Agarwal.
You have
Just take down. There has been no appearance on behalf of the state. Mr. Vijay Agarwal, who's in the court, is requested to appear in the present writ petition. Let his appointment be regularized. He seeks 2 weeks' time to take instruction. Let this matter be listed on so and so. Who's the main party, state or the corporation?
no, municipality.
Municipality.
Municipal.
Just take down. Affidavit of service is taken on record. Petitioner is at liberty to, petitioner is directed to serve the respondent. Respondent number?
My lord,
Respondent number.
respondent number, my lord, 2.
Haldia Municipality. Respondent number 2.
Respondent number 2. Serve the respondent number 2 afresh. Let this matter be listed after 2 weeks. So it is only your, what are you alleging? Unauthorized construction?
Yes, my lord.
All your documents are in vernacular. I can't understand anything.
And I will translate it, my lord.
Better translate it.
Only representation.
What is your case? Tell me your case. What is your case?
Yes, my lord.
Demolition of unauthorized construction.
Demolition of unauthorized construction.
Yes, my lord. The construction, my lord, is under on the vested land, and the respondent number 9 to 14, my lord, private respondents, they have constructed, or some of them are going to construct upon the vested land on the basis of false document, false deed, false record. And I have informed.
Who are you?
I am, my lord, Rayat of adjacent plot of land. And
You are the owner of adjacent plot.
yes, my lord.
You live there.
Yes, my lord.
Your
I
property.
am living there. I am in possession, and I made a representation, my lord, to the municipal administrator. Kindly inquire the matter and dispose of my application in accordance with law. That is only my grievance, my lord. Nothing else. After inquiry, my lord, they will take step.
I am petitioner Akhtar. Under one.
Only my prayer is that, Lord, let the representation that is annexed P4 may be considered in accordance with law, giving opportunity to all the parties.
You had approached the BLRO.
My lord?
BLRO you had approached.
Yeah, I approached BLRO, DLRO, all other authority, but actually.
Then what happened?
All pending, my lord. Not representative has not been considered. That is pending. That is why I have come before the lordship. Only for
File multiple litigation like this, sir. Where is the order of the BLRO final order? There is only order passed.
No order, my lord. Only, my lord, my grievance is that the land is vested land. I have annexed the record, and the respondent, my lord,
BLRO has-
private respondents, they have managed to get their name recorded as right to land, personal land.
That is something which the state has to see. Mr. Agarwal,
Yes,
My lord.
you have to see that.
My lord, I'll.
He's not only alleging unauthorized construction, he's also alleging the fact that land has been acquired illegally.
My lord.
So you file your report
My lord.
and you serve the corporation also.
I have served, my lord.
And not him. You serve the corporation, sir.
Oh, corporation. I have served the corporation, or they have
So,
received.
sir, that's what I have declared.
Yes, madam. Again, I will serve.
And I'm telling you, if your house is illegal, I'll get that also demolished. I'm telling you right now. Your house, you have a sanction plan.
My lord,
Where you are staying, is it a sanctioned house, sanctioned plan?
I am residing there for more than 50 years, madam.
Did you see the recent Supreme Court judgment?
My lord?
Whether you are living for 100 years or 50 years, there has to be some plan.
No, only my lord. Sanction, that is
Let
my
the
lord,
corporation
state
come.
only.
My lord, kindly record Mr. Tripathi will assist me in this matter. A and C both. Two copies served already.
No, but why another person to be assisting?
Normally, from GP office, they two people allow. They allowed two people.
One is enough.
My lord.
দিয়ে যাবো।
8 April. 8/4. Item 64. 64, I am for the petitioner, my lord.
My lord, I am.
Last occasion, your lordship directed me, my lord, to serve, my lord,
I
the.
appear on behalf of the Kolkata Municipal Corporation, my lord. I
Yes.
only prayer, my lord, if they could serve a copy of the application, my lord.
Yes, my lord. I have served my last occasion, as per your lordship direction, my lord, they have received it, my lord. Kindly see, my lord, by hand, my lord, along with the petition. First, I sent by register post, thereafter your lordship directed me to serve it by hand. I again serve, my lord, by hand, my lord.
I'll keep it tomorrow, my lord. May I have a look and come back, madam?
Tomorrow.
They have already issued, my lord.
And the copy may be served.
Yes,
to
madam.
me by
Yes,
two.
Again, my lord, Xerox and my serve it, my lord. আমি অ্যাড্রেসটা দিয়ে কালকে
I'm grateful. ma'am.
একটু লিখে দেবেন। Item 66.
I am for the petitioner.
Private
Allegation
respondent,
is
my
my
lord.
lord that a building,
Howrah Municipal Corporation, my lord.
P+3 building, which I
Pass over, my lord. Mr. Banerjee, Shandipan Banerjee is appearing in this matter for Howrah Municipal Corporation.
You'll have it tomorrow. Tomorrow?
or should they not come with a report? Because my allegation is not regarding 4 additional floors. If they file the report, it's easier. My lord.
I am for the private respondent against whom he has alleged I have made an illegal construction, your lordship. The building has been constructed back in 2018, your lordship. Thereafter, the Howrah Municipal Corporation has levied penalties, have accepted my as-made plan. Let a report be submitted, your lordship. That is also.
The report is submitted.
Petitioner has preferred the present writ petition alleging unauthorized construction in the form of additional 4 floors in Debsoni apartment, block A, situated at Howrah Municipal Holding number 70/1, Nilmani Malik Lane, Howrah. Right?
Malik.
Full stop. Learned counsel for the respondent municipality seeks 2 weeks time to conduct inspection and submit a report in this regard. Learned counsel for the respondent private party. Respond number?
5, your lordship.
Respond number 5 states that her property is there's no illegality in the said property, and all necessary sanctions and compliances have been
They said not that upon penalty it has been regularized. That has been submitted.
Learned counsel for the respondent private
permissible
respond
4
number
floor.
so and so seeks 2 weeks time to file her affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 4 weeks.
Affidavit of service may be not kept with the record.
Affidavit of service is kept on record.
22nd April. Item 68. 68, I am for the petition.
in this
Last
matter,
occasion,
my
your
lord,
lordship
appearing-
directed me, my lord, to serve My notice to my learned friend, I have served, my lord. He is the authority, my lord, to
Sir, I am
consider, my lord.
appearing for respondent number 6 to 9.
Yes, my lord.
Sir, I am praying for 4 weeks time to file opposition.
Because kindly see, my lord, my lord.
এটা চাও তো টাকাটা
চাই
চাও
তো,
তো
চাই।
যা বলছি শোনো
Sujit,
Petitioner retired,
uh,
petitioners, my lord, retired from, died on my. Yes.
হয়তো তার আগেই পেয়ে যাবে হয়তো তার আগেই
Yes.
টাকা
Petitioner is the Group D employee, my lord. In the Murshidabad municipality.
নাম দিলাম তো
Died in hardness, my lord, and 27/7/2020, 2012, my lord. After completing, my lord, 23 years, 7 months, 25 days. Thereafter, my lord, the respondent authority paid, my lord, 3,000 per month as a, my lord, the provisional pension, my lord. Provisional pension in favor of his wife, my lord. Thereafter, my lord, regular pension was granted, my lord, and my lord, the regular pension was granted, my lord. During the provisional period, my lord, the arrear pension and, my lord, the gratuity amount not paid, my lord. So, my lord, the petitioner came before your lordship, my lord. My lord, several representation was made, but they have not released the same, my lord. My humble submission before your lordship, direct the respondent authority to, my lord, grant, my lord, the gratuity amount along with the arrear pension, along with interest, my lord.
should I ask them to decide your representation or you want them to file reply?
Along with, my lord, kindly see the similar circumstances, similar, my lord, municipality, my lord, the pass the similar order, my lord. My lord, and my lord, they have already complied with, along with 9% interest. This is the compliance report also, my lord. This is the, in terms of this order, my lord, the compliance report is there, my lord. Along with 9% interest, my lord, they have granted it, my lord. The gratuity amount along with arrear pension, my lord.
You want your representation to be decided, you want them to file a reply. Without their reply, I'm not going to decide the matter. In the earlier round, the judgment which you have shown,
Yes, my lord.
they had filed their reply stating that they don't have funds.
They have submitted report, my lord. They have submitted report, my lord,
But
by
I'm
way of
asking
affidavit.
you, I will give them time to submit report and then
Yes,
pass
my
it.
lord. Yes, my lord. That's
that?
to submit a report, my lord.
The petitioner has preferred the present writ petition alleging non-release of pensionary benefit of a deceased husband. Husband. It is the case of the petitioner that her husband was an employee of Murshidabad municipality and passed away on 27/7/2012 while working as light supervisor group D full stop. After the death of her husband, pension gratuity order dated 2010-2014 was issued. Full stop. According to the said PPO, pension PPO, bracket में कर देना pension payment order. The gross gratuity to be payable in favor of the petitioner was indicated. Payment was indicated. Gross gratuity to be payable in favor of the petitioner was indicated to be 2,31,252. Full stop. It is the submission of the petitioner that she received only rupees 3,000 towards provisional pension with effect from August 2012. In view of the same, the petitioner has preferred the presented petition seeking arrears of family pension with interest from 28/7/2012 to 31/12/2014 and death gratuity of rupees 2,31,252. Full stop. Learned counsel for the petitioner submits that he has made several representations before the concerned Murshidabad municipality, but till date no response has been received. Full stop. Learned counsel for the respondent municipality seeks 1 week time to file a report. List this matter after 10 days. 1 week time, sir.
No, let it be 2 weeks, my lord.
Pension. I'll give you 2 days. People are dying, you're not making the payment.
Deeply applying.
ये फाइल में डाल दें.
Item 72.
My lord, in this matter, I am appearing on behalf of Bhatpada municipality.
The petitioner.
My lord,
I'm for the state.
my lord, the employees, these are our employee, my lord.
Appearing for?
Bhatpada municipality.
Who's the
I am for the petitioner.
But we have suitably replied the queries of the petitioner, my lord.
Lordship, may I place my
Just
case?
a minute, sir. Let her ask. Yes.
Lordship, the petitioner served with the Bhatpara municipality, Lordship, for 29 years. He was appointed in the year of 1993, 29th of June. And Lordship, he was superannuated on 31st of December 2022, Lordship. It is a 29 years of service, Lordship. He was given a gratuity of 9 years, 11 months only, Lordship. And in the PPO, Lordship, his year of service has also been marked as 9 years, 11 months and 13 days, Lordship. I am praying, Lordship, that he may be paid for the entire period of his service, gratuity along with pension, Lordship, retirement benefits. Lordship, page 43 is the PPO.
Yes.
Lordship, page 43. Lordship, it is the PPO, Lordship.
Yes.
Lordship, here the qualifying service has been marked as 9 years, 11 months and 13 days, Lordship. But Lordship, I was appointed in the year 1993, Lordship. Lordship, kindly comes to page 35, Lordship. Statement on casual staff engaged during 1st of January 1992 to 31st of December 1998, Lordship. At serial number 41, petitioner's name is there, Lordship. Shomit Chandra Sandel. And Lordship, date of engagement is 29th of June 1993, Lordship. It is their document where it has been marked that his date of appointment is 29th of June 1993, Lordship. Lordship, my prayer is that I may be paid for the entire period of 29 years of service, Lordship.
The petitioner has preferred the present petition being
My lord, the
agreed.
factual aspect that he is regularized from the date
File
of
your reply.
regulation.
File your reply.
My lord, we have written a letter to the petitioner.
Put it on affidavit.
Lordship.
My lord, main liability is on the part of the state, my lord. We have sent the entire file to the state of West Bengal for pension.
Put it on affidavit, sir.
My lord. My lord.
Lordship.
Being aggrieved, who appears for the state? You appear for the state. Being aggrieved by the non-payment of interest on delayed payment of gratuity slash comma non-disbursement of gratuity for his entire service career of 29 years,
Lordship.
and also for not
Gratuity
granting-
has been paid.
gratuity has been
Has
Madam,
gratuity?
Lordship.
Yes,
Only
my
for
lord.
Lordship.
Gratuity amount is paid, my lord.
Only for 9 years, Lordship. 9 years and 11 months, Lordship.
you file
He's
your
eligible
reply.
to get
Yes, my lord.
gratuity
PPO
for
issued by
29
the,
years,
File
Lordship.
your reply now.
yes, my lord. PPO issued by the state of
When it
West
comes
Bengal.
to the respondent municipality, respond number, you appear for respond number?
Huh?
Respond number.
Respondent number bolun.
Respondent number, my lord.
Respond number 5.
I am appearing on behalf of respondent number 5.
Respond number 5 takes 4 weeks time to file affidavit in opposition. This same prayer is made for respond number. You appear for
I'm for state.
respond number 1, 2, 1, 2,
1 to 4.
1, 2, 3, 4. Respond number 1, 2, 4 takes 4 weeks time to file his affidavit in opposition. Reply to the same within 2 weeks thereafter. As it goes on, all the respondents seeks 2 weeks time, 4 weeks time to file reply. Affidavit in opposition, reply to the same within 2 weeks thereafter. List after 6 weeks.
My lord, one indulgence, my lord. One indulgence, my lord. My lord, in this matter, my lord, government has already issued
Sir,
PPO, my lord.
Please take
Kindly
it.
record, my lord. Government has already issued PPO.
Sir, am I giving a finding?
No, my lord.
What is wrong with
Sorry, my lord. My lord.
Sir? What kind of submissions are these?
My lord.
I'm giving you the opportunity to
My
put
lord.
everything on record.
My lord.
I have not passed any observations. Then you're getting super excited.
No, no, my lord.
Lordship, I have filed my affidavit of service, Lordship.
29. If that is an
Let me
allegation, the petitioner has preferred the present writ petition.
I have
Allegation.
filed my affidavit of service, Lordship. Grateful, Lordship.
Item number 80.
My lord directed my learned
My
friends
lord,
to
on the
not
last
bring the
occasion,
record.
your lordship pleasure was to direct the corporation to bring the record, my lord. We have received the record just, my lord, a few hours ago, my lord. We need to go through it to understand it in our way so that we can assist the court properly. My lord,
Lord,
we need it.
I will tell you one thing in this matter.
My lord,
Form the corporation.
my lord, I have
Wait a
called the
minute, hear
corporation.
me
The
out.
corporation has come with the my lord, records. My lord, we need to, my lord, go through the same in and assist.
Lord, I understand. I need to tell him 3 clauses of a rule. If my lord also sees this, my lord, the amendment of mutation, just bear with me for 2 minutes so that he can also come back prepared, because this is going to, Lord, if my lord goes into the deep, my lord will find out what has happened. Lord, section 183(5) is the provision of the Corporation Act which deals with mutation. Lord, there can never be any suo motu mutation. There is a rule for mutation, that is Kolkata Municipal Corporation Taxation Rules 1987. Kindly have a look at rule 6 and 7. I have flagged it. Just have a look at. There can never be any suo motu mutation. Rule 6 and 7 flagged on the left hand side page, my lord.
I will satisfy your lordship on all these points. my
কি
lord.
বলছি শুনে নাও, তারপর
না, না, আমি
satisfy
শুনিনি।
করবে। Hear it. Read rule 6 and 7. It is only on an application by a party, either on devolution of interest by inheritance or by purchase.
Well, we have
Lord,
conducted
suppose there are
mutation, my lord,
10,000.
only for the purpose of apportionment.
Both of us cannot speak together. Suppose there are the Can you read it, rule 6 and 7? একটা বইয়ের কপি আনা উচিত ছিল, কি বলবো, আমার কাছেই ছিল, আমি আনতাম। And there are other 2 flag marks, my lord Kali says those are the forms under which it should be done. Kali, take those other flags. I have flagged it for your lordships. Form D and Form E. I'm so sorry, my lord. Form D and Form E. Form D is the information, Form E post mutation information. Here it is a case where the corporation does it suo motu Under what law? Where is the provision? And now today I am carrying a beta copy for my lord. Beta copy to thou?
When do you want it?
Yes.
Let any day, my lord, the next week, any day.
We'll have it on Monday.
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 Monday, there may be a chance that there may be Eid, my lord, may spill over on Monday.
Tuesday.
Tuesday keeps it. And my lord, may I beseech your lordships, my lord, request him through your lordships, whatever record that he wants to produce, if I can get an inspection on this Friday.
Let him make his submission. We'll see that.
If I could inspect the record, it will be easier for me to apprise your lordship. My lord, so
Yes,
pleases.
At
his office, can I take an inspection?
I can tell you one thing. Land can't disappear.
Yes, that's the point.
I'll
There
initiate.
is only one problem.
initiate
One
the
problem so
inquiry
far
in
our
this.
understanding is concerned. Malad, two numbers are given. Paras malad in respect of
I'm
only
telling you, sir.
single premises. Malad.
I'm telling you.
Intelligent.
Tell your officers.
Ekdam dhoran.
Heads will roll.
That will satisfy your lordship. And so far, malad, so moto mutation is
Somebody
concerned. That
will
is
go
for
to
the
jail.
purpose of apportionment only, malad.
Yes.
Tuesday.
So Tuesday will come back.
'84.
I beg to appear for the private respondent number 12.
Milord, apropos the allegations contained in the representation, Milord, regarding the functioning of the private respondent divorce, any permission from the authorities, Milord, I am before your lordship's court. Milord, the municipality is today fortunately here. Yesterday it was not there in the other matter. Milord, I am also a similarly circumstanced citizen of Srirampur municipality. Milord, I am seeking to, Milord, ventilate my grievances over functioning of one food stall, Milord, by the private respondents without obtaining the necessary permission and licenses from the authorities. That is the sum and substance. Milord, the municipality is here. If they can persuade, Milord, file a report or say whatever they want to say, Milord, I leave it to your lordship.
So far as the municipality is concerned, before they address your lordship, I should be candid enough to indicate that the petitioner does not have a locus standi to maintain the writ petition. Number one. Number two, the private respondent number 12 has been made a party, whereas she is no one to.
Why they don't have a locus standi?
Because they are not, none of their legal right is affected, and this is not a public interest litigation.
If there's an illegality, anybody can.
Insofar as illegality is concerned, what is the cause of action insofar as his legal right is concerned that has been affected?
But you appear for the municipality.
For the private respondent. And the private respondent is not a necessary party. Insofar as the private respondent is concerned, they have stated categorically, my lord, that she is the owner of, she has been made a party because she is the owner or rather proprietor of this particular concern, which is carrying on the business. But your lordship,
for the municipality, you appear. Yes.
There was a notice not served upon the private respondent.
Yes.
The private respondent's husband, Mr. Vikas Saha, appeared in the inquiry. What we find is that he placed the flat for this purpose, does not have a sanctioned flat. It is neither sanctioned commercially, there is no plan at all. And so far as the license of the
So close the
there is a civil suit pending and there is a stay.
It's not with regard to the sanctioned flat. I am saying, but we have inquired.
Take action. If there's no.
They have already.
Sir, don't speak in between. I don't like this habit.
I apologize, my lord.
I gave you time.
I understand. Please do not take me amiss, my lord.
Fire license is not there, and the trade license, for trade license, two things are required. One is a sanctioned building plan, another is a NOC. So far as if a person is a rented person,
So you are admitting the fact that the trade is being carried out illegally, then you shut it down.
We were actually as the petition was filed, we just waited for the pay to come. This is the answer.
we are on the verge of cancelling the trade license and directing them to stop it.
So, then I'll ask them to decide the representation. They'll decide it.
May I submit one thing, my lord, before your lordship passes the order?
My lord, yes. My lord, if your lordship so feels, my lord, your lordship may record his submission.
And my lord, may I make a submission, my lord? My lord kindly peruses these two documents. It was a trade license, because my husband, it's a business of my husband, and I have been made a party here. The entire, this is at the behest of a promoter. The third party is being brought into the picture, and all sort of vengeance has been struck against me. The building has been demolished. I took a stay order from the civil court, whereby the portion which is under my tenancy has not been touched by the municipality. Entire building has been demolished.
And electricity connection?
Commercial connection, which has been effective from 13/12.
Or
Correction. And they are regularly has granted a commercial connection to residential.
With the commercial connection, they applied for it, we have given the
but did you check the documents? Did you verify that? All right, I'll dispose it of then. The petitioner is aggrieved by the petitioner has preferred the present writ petition being aggrieved by inaction on part of the respondent municipality in not taking action against the respondent. Number 9, for committing gross illegalities in running the shop / outlet of bracket inverted commas में करते ना Saha Drink at 33 NS Avenue, Sirampur Municipality, District Hooghly. It is the case of the petitioner that the said shop is being run without valid trade license. Full stop. Even though it is a commercial venture, they are enjoying. No, even though the property is it's a residential property, they are enjoying commercial connection, commercial electricity connection on the said property. Full stop. Learned counsel for the petitioner points out that they have made a representation before the municipality on 14/1/2025, highlighting all the above, all these illegalities, however, no action has been taken by the respondent authority. Full stop. Learned counsel for the respondent municipality, Shirampur municipality, submits that there's an illegal construction in the above mentioned property, and that the trade business is being run without any valid license, without any valid fire license as well as trade license.
You are the verge of cancellation because after this complete on the.
But you have not cancelled it right now.
No, on 21st February 2025.
Without any valid fire license. It is further stated by the respondent authority that they are ready and willing to decide petitioner's representation dated 14 January 2025 in a time-bound manner, preferably within 4 weeks from the date of communication of this order, after affording an opportunity of hearing to the petitioner as well as all the respondents. ये पास इसको चेंज कर लो आप learned counsel they will decide petition they are ready and willing to decide petitioner's representation dated 14 January 2025 full stop. It is stated by counsel for the respondent municipality that they have already afforded an opportunity of personal hearing to the petitioner as well as all the other interested parties and are in the process of passing of a speaking order. Full stop. It is stated by the counsel for the respondent authority that they will pass the speaking order within a period of 2 weeks, within a period of 2 weeks from the date of communication of this order. Full stop. Learned counsel for the petitioner states that he is satisfied with the statement made by the counsel for the respondent authority. Full stop. This court directs the respondent authority to pass the necessary speaking order within a period of 2 weeks from the date of communication of this order. With the above direction, the presented petition is dismissed.
Item 87.
87, my lord, I appear for the petitioner.
My lord, I am appearing on behalf of Kolkata Municipal Corporation, my lord.
I am the permissive occupier of a certain commercial space in Kolkata. Now, my lord, the private respondents has encroached upon my land, started construction without any sanction plan. This is my grievance. I have addressed representations, not considered, no steps has been taken.
I have considered the application of the petitioner. I have inspected the premises. I have already served the notice for stop work under section 401 and I have intimated to the local PS. Even I have already proceeded under 400 subsection 8 to demolish the building and it might be demolished in next month, mile. I'll record that, dispose it off. If petitioner agree, then I can give a copy of the direction of the municipal corporation. Submission, I'll dispose it.
Only one accommodation. Kindly keep the petition pending, my lord. Kindly keep the
There's no point keeping it.
file a police report, but otherwise,
They'll decide. You are at liberty. The petition has preferred the present petition alleging unauthorized construction at premises number 11/1 Topsia Road South, Post Office, Gobinda Khatik Road PS Posia, Kolkata at the instance of private respondents. Who are the private respondents here? Private respondent number?
Mulad, private respondent number, Mulad 12 to
18. Private respondent 12 to 18. Full stop. Learned counsel for the respondent municipality, Mr.
Vimal Kumar Shahi.
Vimal Kumar?
SHAHI.
Vimal Kumar Shahi states that the corporation has already inspected the property. Work stop notice has already been issued. Notice for demolition has been served upon the petitioner. Full stop.
May I allow to submit mine? Already I have intimated to local police station also mine.
A copy of the work stop notice has also been given to the local police station.
Mine.
Full stop. They are. When do you intend demolishing the property?
Hello?
When do you intend doing the?
In the month of April, my lord, there are a few formalities there. After completion of the formalities, it will be done.
The learned counsel, the respondent further submits that all necessary demolition order and action, if so permissible in law, shall be taken within a period of 6 weeks. 6 weeks?
Next week, ma'am.
Within 6 weeks.
6 weeks বলছে 6 weeks 6 সপ্তাহের মধ্যে বলছে
My lord, 6 weeks.
Within a period of 6 weeks. In view of the statement made by the learned counsel, the respondent, the petitioner states that his grievances are satisfied. This court deems it appropriate to direct the respondent municipality to comply with the statement made before this court and shall take necessary action regarding the unauthorized construction if the same is not permissible in law within a period of 6 weeks from the date of communication of this order. With the above direction, the present writ petition is disposed of.
grateful
Grateful, my lord. I am appealing for the statement.
Rest of the matters after lunch.
The next item, my lord, item 95, my lord, can it stand over till first, my lord? The service is not complete.
Who's for the petitioner?
My lord, I am for the petitioner.
All right.
Can it stand over till first, my lord? Second, my lord. Service is
Not today.
2 tarikh, 95.
Yes.
Item number 97.
Not today.
99.
My application. Service, my lord, had directed to a fresh service upon the Uluberia municipality. My lord, hand service has been made upon Mr. Gaurang, Mr. Govinda Chandra Bandyopadhyay, who appears for the Uluberia municipality. I've served him personally. My lord, very simple matter kindly comes to page 17. My lord, for a water connection. I'm seeking only a water connection. I have paid the fee. I'm a 70-year-old lady. For drinking water, my lord, the municipality is obliged.
Take down. Petitioner has filed this writ petition seeking water connection to his premises. Situated at Dag number 1204, RS, Khaitan number 73, Mauza, Fuleshwar, jail number 108, village Kush Beria, PS Kuluberia, district Havra. It is the case of the petitioner that he had applied for a domestic water connection and had deposited the quotation money on 24/8/2024, full stop. However, till date, no water connection has been granted to the petitioner. Full stop. This court by order dated 23/2025 had directed the petitioner to serve the respondent number 2 and 3 afresh, despite an affidavit of service had already been filed by the petitioner. Full stop. Petitioner has handed over a copy of service effected upon the counsel for respondent number 2 and 3, Mr. Govinda Chandra Bandyopadhyay. Full stop.
21st March করেছি।
There is, despite service, there is no appearance on behalf of the respondent number 2 and 3. Full stop. This court directs the respondent number, since the petitioner has already made a representation, made an application for a fresh, yes.
For Uluberia municipality, my lord.
Yes, sir.
My lord, I have received the brief yesterday, my lord. Just I have yet to receive instruction. Kindly tomorrow may kindly fix matter.
क्या लिखवाया फिर इसको चेंज कर वो छोड़ दो
আমার মামলা আছে বাইরে
अमाउंट कर दो कोटेशन अमाउंट on 24 बस उसके बाद लिखो respond number Mr. So and so appears on behalf of respond number 2 and 3 and seeks 1 week time to take instruction. Let this matter be listed on Tuesday. Tuesday.
Tomorrow.
Tuesday. You take instruction. Come back.
Item number 100, my lord. I beg to appear on behalf of the petitioner. Lord, this matter, my lord.
11 and 12.
State,
my lord.
Appearing on behalf of the Uttar Pradesh Court of Municipality, my lord. I am for the 9 and 10.
Lord, this matter, my lord, pertains to illegal construction on a land. Lord, my contention is that the land where the building has been erected belongs to my predecessor in interest. Therefore, my lord, if any sanction plan, if at all, has been obtained by the private respondents, that has been obtained, my lord, by misrepresentation of facts. Now, my lord, therefore, my lord, in the West Bengal Municipal Act, my lord, prescribes Section 217 that if any sanction plan is, my lord, obtained by misrepresentation, that has to be, my lord, quashed. My lord, all I want, my lord, my representation to be considered by the chairman, only that, nothing else. Page 126A.
If you feel that the sanction plan is illegally granted, you can approach the, you must be having a tribunal.
No, my lord, there is no tribunal. First, my lord, that has to be decided by the chairman. If anybody is aggrieved, there, and my lord, if my instruction is, my lord, there is no tribunal.
My lord.
Yes.
My lord, the Board of Councillors has a power to regarding demolition of the any illegal construction. My lord. My lord, the construction is old construction, my lord. It is not a new construction, my lord. My lord, kindly look into the paragraph 7, my lord.
My lord, may I allow to submit the instruction which I received from the local PS, my lord?
Local police.
Uttar Pada, Inspector in charge, Uttar Pada Police Station, my lord.
What is it? Tell me.
Basically, there are two co-shareholders who have sold their properties.
Yes.
The fact is, my lord, this is a civil nature of dispute, my lord. And without resolving the civil nature of dispute, how petitioner claim demolition of the building? It might be. He may be two co-shareholder. But there are dispute among the 4 co-shareholder, my lord, in this premises.
What else?
First of all, my lord, petitioner have to move this matter before the civil court.
Let me tell you one thing.
My lord.
For any unauthorized construction, nobody has to go anywhere.
No, not for the unauthorized construction, my lord. I am not going in that part.
He is not asking for a civil rights. He is not asking for the property to be divided by metes and bounds. He is alleging in this writ petition that there is unauthorized construction. And if there is unauthorized construction by whosoever it is, that has to be demolished.
Lordship, may I submit? I'm for respondent number 11 and 12, Lordship.
Yes, you are the one carrying out the unauthorized construction.
Lordship,
Yes.
I have already sold the property to the respondent number 10. And Lordship, this was a vested property, vested land, which was mutated in the year 1987. And it was recorded in the name of Krishna Chandra Das, the father of the respondent number 11 and 12 in the year 1989. Since then, they never claimed, never challenged.
Is there any unauthorized construction going on today? As of today, is there any construction going on in the property?
I am for this 9 property disputes. There is no such illegal questions going on. I have obtained the sanction plan. I have the mutation certificate. After obtaining all the complying all the rules and regulations, I am constructing the building there.
My lord, let this be verified by the municipality by giving me a hearing.
Totally false and
Because I have, my lord, challenged the veracity that if at all any plan has been given. Yes, my lord.
Yes, madam. Fine.
Yes, report to-
The petition is aggrieved
I want to copy things.
by the inaction on part of the respondent municipality. By the petition is aggrieved by the unauthorized construction being carried out at the premises in question. It is the case of the petitioner that the respondent municipality has failed to take any action on the ongoing unauthorized construction. Full stop. Learned counsel for the respondent municipality seeks respondent number 6-7. You appear for respondent number 6-7, right?
Yes, madam. I am appearing on behalf of
Respondent number 6 and 7, municipality seeks. How much time?
Madam, 4 weeks time, madam. Inquiry and report.
Then you file your affidavit in opposition. Then you take down.
My
All
lord,
respondents are here.
My lord may always also dispose of by directing the municipality to give me a hearing, dispose of my.
Not disposing it of anything.
Grateful, my lord.
4 weeks time.
Reply if any 1 week.
Respondent
Time of inquiry.
takes 4 week time to file their affidavit in opposition. Reply to the same if any within 2 weeks thereafter, just after 6 weeks.
Grateful, my lord.
But at the time of inquiry in local, kindly give direction to the local PS mallet for assistance.
File your affidavit in opposition.
My lord.
Grateful.
Highly obliged, my lord.
Highly obliged.
Yes. Lordship, in this matter, I am the writ petitioner. The concerned building property has 7 corners. We the
I am paying for the respondent number 3.
I'm appealing for respondent number 9.
Your Honor, the concerned building property has 9 corners. About 2 decades ago, as per the sanction building plan, this building was constructed where this is a 3-story building where the ground floor, where only there were 5 shop rooms were sanctioned for the ground floor. Rest of the building is the residential building property. In the meanwhile, what we see that without the permission of the other corners, one of the corner has let out a portion of it, and that is the first floor, which is a residential part of the building. Your Honor, I'm coming to my writ petition, page number, Your Honor, affidavit of service. Your Honor, I'm coming to page number 40. This is a photo, annexure P5. Annexure P5. Your Lordship will see that from here that the private respondent number 8 is running a restaurant. Is running a restaurant from the ground floor and from the first floor. Now the ground floor, it is all commercial sanctioned 5 shops, out of which they are running from the 2 shops. I'm not on that point. On the first floor, what they have done is they have broken one of the shop room, broken the floor, taken over the first floor, the residential first floor of the building, and they have started a restaurant here, which is totally against law, which is totally against the mandate of law as stipulated under section 416 of KMC Act. Your Honor, I'm coming to the provision of law also. Lordship, I'm coming.
Who appears for the corporation here?
Well, I've taken an action because after having the
information, my lord, which are authentic, they did an inquiry to the spot. And we have found that the first floor, a part of the first floor has been converted to a different, my lord, the purpose. And we have already issued a notice work to stop the progress of any work in the premises, and the police has also been intimated to take necessary steps. And so far as the proceeding is concerned, my lord, we have been differently staged regarding the demolition stage and to process the case under particular provisions of the law. This is when I have got a report in writing from the authorities. Therefore, my lord, if grievances has been, my lord, have been taken care of, it has been addressed, and all that he could say, my lord, that whatever the actions to be proposed or are taken by the corporation at their level, my lord, it is to be intimated to the petition.
My lord, may I submit and for the respondent number 8? It actually enters a dispute between the courts.
I am not getting into that. I am only on the unauthorized construction part. Usage. Unauthorized use.
The petitioner himself has obtained an order of status quo by the learned civil court. It is pending.
No, there's a partition suit pending that we am on
I am
KMC
not
Act.
getting into it.
I am under just study provisions of Calcutta Municipal
I am
Corporation Act,
not getting into
section
it.
416. Lordship, there are two issues.
Where is the corporation report? So they are taking action.
No, Lordship, there are two issues. One is unauthorized construction against the change of user in violation of section
They are
416.
taking care of that. They are taking care of that.
Let it be, the process be done early. There should not be an excessive delay. That's I'll leave it
Shall
to
I
your
dispose
Lordship.
it off?
I'll leave it to your Lordship.
Shall I dispose it off?
Maybe it's to dispose it of on the basis of the proceed in terms of the.
No, I will dispose it off in terms of the fact that you decide his representation.
Decided to proceed in respect to the issue in question.
No, decide his representation. You already.
That could also be done.
Lordship, time bound, please.
That could also be
I will much.
ये लिख लो. The petition is the petitioner in the present writ petition is alleging illegal running of a shop. Is it a shop?
Restaurant
Running of a restaurant.
from the first floor.
Running of a restaurant in a residential flat without the change of usage into a commercial property. Full stop. It is also alleged that there are unauthorized construction in the said property. The petitioner had made several representations. The last being representation When did you file the last one? 13th?
Yes.
13/2.
Yes, yes. Yes, Lordship.
Give me the date of the last representation. The last being representation dated. Dated 13/2.
13/2. 13/2. Yes, Lordship.
No, last is 25th November 2024.
Yes.
Check it, check it. Check the record. Give me the exact date.
I am just.
Last one. 25th November 2020.
25th November. Number 20.
Mr. Ghosh, who appears for the respondent municipality, states that already an inspection has been conducted, and it has been found that without the change of usage, commercial activity in the nature of a restaurant is being run from the concerned property. Full stop. It is also submitted by him that during the inspection, respondent was not able to show any legal plan or authentic documents in support of either the construction nor any change in use of the property. Respondent. He further states that a work stop notice under section 401 of the KMC Act 1980 has been served upon the responsible person on 3/3/2025 wide notice number 104 dated 3/3/2025, and even the local police station Karaya has been informed in this regard. He further states that the present writ petition can be. He further states that the respondent corporation is ready and willing to dispose of the representation dated 25th November 2024 within a time-bound manner, preferably within a period of 6 weeks, 4 weeks, within a period.
By the engineer,
Within a period of 4 weeks from the date of communication of this order, after affording an opportunity of hearing to the petitioner as well as all his petitioner accepts the submission and states that he does not wish to press the present writ petition. Full stop. This court directs the respondent, Calcutta Municipal Corporation, to decide the representation of the petitioner in the above terms. With this direction, the present writ petition is disposed of. Affidavit of service is taken on record. ऊपर ही लिख लेना.
मैं सर्विस दे दीजिए এটাকে কি বলবা তো ব্যাস
109.
May it please your lordship. My lord, there is a very slight deviation from a cause of action which has up to now been unsuccessfully espoused and the cause of action of the present writ petition. The deviation is absolutely fine, but palpable. Now, for that purpose, my lord, I would be required, my lord, to bring on record the association's writ petition, my lord, which I have got in the meantime. Unless I bring the association's writ petition on record, chances are that the opposition will say, and the respondents will rightly say, chances are that your cause of action is already covered by the association's approach to the honorable court and to the division bench. My cause of action is slightly beyond that, and it doesn't depend on whether I have proprietary rights over the soil. That will be, my lord, my submission. I'll just brief the brief in half a second. There's a building at 227 Acharya Jagadish Chandra Bose Road. This is a huge property, contains commercial units, few residential units, about 10%. This building, as a part and parcel of the building, had a 700 square meter land in front. This is just, my lord, for the bird's eye view. This will require greater scrutiny perhaps later, subject to the writ petition being admitted. So this 700 square meters of land was part and parcel of 227 AJC Bose Road. Kolkata Corporation sanctioned a plan on the basis of which the multi-storied building has come up. In that plan, the 700 square meters of land are shown to be containing car parking spaces, which service the flat or the apartment owners of the building. Original plan is missing from the custody of the corporation. There are two versions of the alleged copy of the plan which are doing the rounds. One with the original owners who have subsequently sold to an entity called City Enclave. The other with the association. Both purport to be copies of the plan, but they are different, slightly different in nature. But in respect of both, this 700 square meters is part and parcel of the original premise. Now what happens is, it is mentioned in the deeds that this 700 square meters at the time of the grant of sanction of the plan was under acquisition of the authorities. Subsequently, the authorities deacquisitioned the land and gave it back. Question is, who would get the land? Would the association get the land, or the members of the association as and by way of a part and parcel of the common areas? Or would the original owner get the land, because at the time when the sanction was given, the land was not, the title to the land belonged to the government because of the urban land ceiling proceedings? That was the question. On this aspect, there have been multiple litigations of civil nature. Prima facie, it has been found that the owner, the association of the apartment owners, does not have any proprietary right over the land. Suits are pending. Now the suits have yet been decreed on contest, but prima facie orders have gone against the association on the question of interim relief, qua that 700. What happens now is, this 700 square meters is sold by the original owners, Jenny Christensen, to City Enclave Private Limited, a private respondent. City Enclave applies and obtains a mutation and separation of this 700, hives it off and says that give it a separate premises number. Corporation, without hearing anybody, gives it a separate premises number. So now there are two premises officially in the records. 227 as it originally was, 700 square meters of the 227 hived off as 227A. On this 227A, the corporation has sanctioned a plan. There are two attacks to this plan or the hiving off. First attack is on the question of proprietary right or title. There, prima facie, it has been found that there is no document showing that there is any proprietary right over that land of the association. That's division bench of our honorable court. Second attack, and quite separate from this and not hinging at all on that proprietary right, is assuming I am a resident of the building. Please take it that I am a resident, though I am an owner, please take it that I am a resident just having possessory rights. The Jadavpur University in a recent inspection which it has held at my instance, of course, funded by me, therefore that will not be sacrosanct, but at least has come on record certifying that this 700 square meters of land was married to the original sanction. It was part and parcel of the open areas required to be kept vacant. So even if no one has title to it, that portion of open land will have to service the original premises.
And who's this Jadavpur?
Jadavpur University, my lord, is a university of some repute here.
That I know. Who are they? In this entire dispute, who are
No, they are the experts. Section 45 Evidence Act, expert
to decide land title? No, wait.
No, not title, not title at all. Not title at all. That's why I'm saying.
Expert to decide rights of people.
Expert to decide the application of the KMC building rules and the erstwhile Schedule 16 of the KMC Act, whether they apply here or not.
Are they authorized under the Act?
Under the Act, no, but then they have a Department of Construction Engineering, which your lordships rely on.
To teach, not get into these things.
My lords?
They should teach.
No, they have a Department of Construction Engineering which doesn't only teach, it takes active part like IITs. The IITs, they give opinions, my lord, on the basis of requisitions made. I am not suggesting that that opinion is sacrosanct. I am not saying that it is unimpeachable, but at least they have given that opinion. Now, my lord, today I am faced with this situation here. I, the writ petitioner, have made a representation to the corporation authorities pretty recently, but time for consideration of that has already elapsed. A reasonable time has gone. In that representation, the only 2 points which we are raising is this. This has nothing to do with whether we have title or not. First is, under the Municipal Act, under Section 178, no separation could have been granted of the 700 square meters of land because of the fact that it is married to the earlier sanction. Second, no amount of new construction could have been permitted on the 700 square meters, which has been permitted by a plan, because of the fact that the open areas of the original premises have been pressed into service as site for sanction here. Both of these are dehorsed the rules. So these are my only 2 attacks here. But I must tell your lordship, lord, when I am appearing before your lordship, I must come clean. That is the first requirement, lord, before a court of equity. There are 2 things that from you. My lord, I'm obliged, deeply obliged. Two requirements. One, if I come clean, then not exactly on these 2 points, but on a point of title or perceived interest over that 700 square meters, an application for revocation of the sanction had been made by the association of which I am a member. That association's writ petition was not, the prayers were not granted by the Honorable Single Judge. From there, my lord, a division bench was approached by way of an appeal. Taking that appeal along with 2 other appeals in similar matters of the same premises, the Honorable Division Bench disposed of the matters, appeals, without pronouncing on that writ petition. By mistake. We take it that by mistake. Therefore, my lord, the association carried this in review before the Supreme, in an SLP before the Supreme Court. Supreme Court said,
Review should have filed before the division.
Immediately review before division bench. That's what the Supreme Court said. We filed a review. And we said that, listen, there were 3 writ petitions which had come up, out of which this writ petition, the association says that out of which this writ petition and the prayers made therein have not been considered and hence have not been answered. That review is now pending before the Honorable Division Bench. It was being heard, my lord, on a day-to-day basis about 6 or 7 months earlier. Thereafter, my lord, it is now pending. My learned friends are there, they are contesting. The corporation is also there, they are contesting. Now, that review would have some effect on this, because if the division bench says that no, we've decided one way or the other, whatever is there, so under explanation 5 to section 11 of the Code of Civil Procedure, whatever else we've not granted is deemed to have been refused. If the division bench says that in review, then part of the twig on which I am there will be chopped. If the division bench says, no, I'm opening it up and keeping it open, then I will be aided, because part of that will inure to my benefit. The title issue will also be kept open then. But independently, my writ petition stands on the dual footings of violation of Municipal Act and rules, which can be brought to the notice of the court by any person in occupation. I am in occupation and I stand to suffer, irrespective of whether I have any proprietary right over that frontal 700. So, my lord, I was humbly beseeching yesterday, my lord, I did not have, my lord, the privilege of addressing your lordship personally. My lord, I humbly beseeching only this. Our review is on board. The association's review is on board. As far as I am concerned, I am an owner. So I hold a derivative interest from the association. I will have to sink or swim with it, qua that cause of action. If your lordship permits me, I can bring these additional materials on record, including whatever will happen in the review after a period of a fortnight.
No need.
My lords?
No need.
Here,
How's this writ petition maintainable?
this writ petition, my lord, is maintainable only on two aspects. Kindly see, my lord, the representation that has been made. Please come to, my lord.
Because if you have gone
I have not
on
gone. The association has gone.
397,
Yeah, association.
you are part of the association.
I'm a member of the association. I'm bound.
Member of the association is part of the association.
Yes.
Isn't it?
Yes. Representative interest. Yes.
I
yes.
love your married to the plan. So let's coin some other word for this one.
Let us say, my lord, it's subsumed by the plan. Let's bring it that way.
Oh.
Married, my lord, takes it in a different route altogether. Especially in these days where marriages appear to be more problematic than profitable.
So basically, you are asking for the same thing.
Basically, our grounds are different.
This is second round of litigation on the same cause of action by a different person. Nothing more.
If your lordship takes it holistically, without considering that.
No, I'll consider. This is my prima facie view.
Okay. Now, in order to make your lordship, my lord, perhaps my lord change your lordship's view only to a slight extent. If I place the writ petition of the association and this one, my lord will see that there are these 2 points
No,
which
you
were
stand
not
on your own foot. I don't
on my
need to
own
see-
footing.
Yes.
Then, my lord, kindly gives me a
Sure.
second. Yes. Please come, my lord, to who I am and what I have said I am. I am, my lord, one of the owners, and I have purchased originally from Jenny Christensen Private Limited, Apartments Private Limited.
Mr. Ghosh is sitting silently.
That's ominous, my lord. The amount of silence he's maintaining is very ominous. Ordinarily, Mr. Ghosh is up in arms. If he isn't, then there's something dreadfully wrong either with me or my case.
Yes,
Now, my lord, could I then do this, my lord? I was just humbly kindly keep maintainability open. Would a short affidavit be exchanged? Lordship wants to enter it. I'm grateful. My lord, would your lordship kindly take up who I am?
To which page?
Yes, please come to the detail detail copy. Just a second, my lord.
It's 368.
Thank you, brother. 368 আমার দিক তো নয় ভাই 42. Please come to page 42. কি করছিস?
Yes.
So, my lord, this is my mother deed to which, my lord, by which I am bound. Page 42, annexure P1. Please see, my lord, Jenny Christensen Apartments, Service Apartments Limited, which is the vendor. And, my lord, the person's Ashok Tubes, which is the purchaser. Now, my lord, the entire reference is given, my lord, in the recitals. Please come to page 44. This speaks of this land at 700 square meters. I'll just give you, lordship, a brief thing of page 44. Recital C. In the proceeding under the Urban Land Sealing and Regulation Act 1976 by a final order dated such and such, 21st January 1984, the premises was found to contain an excess vacant land to the extent of 1079.39 square meters, and out of the same, 379.39 square meters was allowed to be held and utilized for construction of a new building, and the balance 700 square meters on the front side was directed to be kept vacant for acquisition in accordance with law. Now, by a conveyance dated 17 July, the said Bikash Chandra Sinha sold and transferred the said premises to the vendor, subject only to the said order of the Urban Land Sealing Authorities and the said lease in favor of the lessee. Lordship turns over, my lord. by an indenture dated 16th October 1983, the lessee surrendered the said lease to the vendor absolutely. In the circumstances, the vendor became and is fully and sufficiently entitled to the premises, free from all encumbrances whatsoever, save only to the limitations and exceptions as mentioned in recital C aforesaid. C mentions about that 700 square meters have been kept apart. Now, my lord, this is the transfer of estate in fee simple. Page 46, my lord, sees is the testatum clause. And there are the usual covenants. And there is, my lord, a mention of the common areas and common portions. There's a mention of the plan. Please see, my lord, at page 52 of my lord's brief, my lord, a mention of the plan. This is the plan which I say has subsumed the 700 square meters. That's clause 8. Plans shall mean the plan, drawings and specifications of the building and or sanctioned by the Calcutta Municipal Corporation, being plan sanction number 3B such and such, dated something February 1986, and subject to such alterations therein from time to time made with the approval of the said architect. Now, my lord, this is the plan that's referred to here, on the basis of which the construction has been made. Please come to page 54.
Just read the next para also.
Yes, my lords.
Para 9.
Premises, my lord, I'm grateful. The premises shall mean the land comprised in premises number 227 Acharya Jagadish Chandra Bose Road, Calcutta, as described in the second schedule hereto, but shall wherever exclude the portion measuring 700 square meters earmarked for acquisition. That is what I was trying to show you in the schedule also, my lords. Kindly come to page 54. If your lordship sees the second schedule, piece and parcel, all that piece and parcel of land containing, according to the title deeds, an area of 2 bighas, 2 kathas, 7 chitaks and 7 square feet of land.
Excluding 700 square meters.
Excluding 700 square meters. So that is the manner in which it has been conveyed to my predecessor. That is the manner in which it has been conveyed to me. Title-wise over that 700 square meters, therefore I do not have any proprietary right prima facie. Only
700 is married to that.
700 is my lord, subsumed by that sanction.
Subsumed.
Subsumed by, let's marry it, my lord, let's marry it to the sanction.
Drop married.
By my lords.
Drop the word married.
Drop the word married. Subsumed by the sanction. This 700 is subsumed by the original sanction. So I step into the shoes of this Ashok. What do I have? I have a right over the flat, over common areas. 700 is squarely outside my proprietary right bundle. It's beyond it. But I am a resident of 227. Now what happens is this 700 is hived off and mutated and separated by the corporation under section 178, which they couldn't have done. Please have a look at section 178. And I'll show, my lord, how it is a cause of action for me.
Why they can do it?
My lords, they cannot, my lord, made a school submission. Please have a
Mutation can be done.
My lords, separation is allowable as a statutory event, but in respect of independent premises.
So
please have a look at
section 142 something. There's some section.
142 is, my lord, rule 142, that was sanctioned. This is 178. Please have a look.
Which one?
178. Kolkata Municipal Corporation Act 1980, my lords.
$178.
My lords. Please come to 178. This is where the concept of separation arises. State government may, by rules provided for the detailed procedure for determination of annual value, etc. Kindly come to subsection 2. I will take your lordship only to the main ones. Under the rules as aforesaid, every building together with the site and the land appurtenant thereto shall be assessed as a single unit.
Where are you reading?
I am reading 178.2. Please see 178.2, my lord. Under the rules as aforesaid, every building together with the site and the land appurtenant thereto shall be assessed as a single unit, provided that where portions of any building together with the site and the land appurtenant thereto are vertically divisible and are separately owned so as to be entirely independent and capable of separate enjoyment, notwithstanding the fact that access to such separate portions is made through a common passage or a common staircase, such separately owned portions may be assessed separately.
Sir, this is for purposes of property tax.
Assessment, but separation comes from this.
Property tax, when you're assessing property tax, any land which is pertinent to the property tax
Has to be taken as a part of the unit.
has to be taken. This has got nothing to do with the building bylaws.
If your lordship kindly sees,
Nothing to do with it.
I'm grateful, my lord. If your lordship kindly sees sanction, my lord will not find any other provision for separation. Separation is if it is independently enjoyable, that then only you can separate. Otherwise, you can't. Now, the entire submission is if it is a part of the spaces already subsumed by an earlier plan. Today, can you hive it off and give it a separate premises number for it to be applied for and be the subject matter of another sanction? Then if that happens, my lords, then kindly consider, my lord, what kind of my lord, situation might happen. Today, my lord, in a building, if a portion is shown as an open space and that portion is huge, then that can tomorrow be given off to another person independently who will only take that portion, treat it as a site for sanction and get another building sanctioned on that.
That's
In the
not-
open space
that's
of
not
that.
How it is done, sir.
My lords.
In the building sanction plan, whatever the sanction is done is according to the plot size.
Plot size.
And only the FAR is given according to the plot size. And that is the construction. It has got nothing to do with the land which is on the side or on the demarcations can be done, mutation can be done, a separate plot can also be carved. And a new municipal number can be appended to it.
My lord, grateful. My lord, only kindly considers this. Let us say, my lord, is a building has been constructed on a portion of the land, a portion of the land kept vacant. That vacant land is one of the conditions of sanction. Under the law, you are required to keep 1/3 vacant. So you've kept 1/3 vacant.
Separate thing altogether.
And that's a condition of sanction.
If
Sanction
you can
of
show me
my lords.
that in their sanction plan, they have taken this land into consideration and the sanction has been accorded by showing this land. You have a case.
Yes, I can show that from the plan. I can show that from the plan. I can show that from the plan because they had put the car parking spaces there. In earlier litigation, sanctioned car parking spaces. These are also, my lord, part and parcel of sanction. Part and parcel of sanction.
Car parking again is a different law altogether.
Yes, it's covered by the same rules. My lord. Yeah, subject to your lordship's correction, it's covered by the same rules. My lord, I appreciate what's my lord, falling from your lordship, but kindly considers it this way. Car parking has to be a part of the sanction. Car parking is an integral part. So if there are 30 buildings and there are 30 car parks sanctioned on the open space, then that together is a land building paradigm which has to be kept untouched. Tomorrow, a person X cannot buy out portion of that car parking land and say it's a completely new land for sanction, get a separate premises number and get a building on that. Then what happens to my building? What happens to my car parks? These are the questions I'm asking myself. I may not have...
How did the single bench answer this question? And in the division bench, how did they answer this question?
Single bench...
If I go by your argument,
yes,
then the fact that you were challenging the sanction plan under section 397, that has already been turned down. And all these arguments would have been advanced at that stage. To that extent, you are trying to say that my parking right is more important. The court would have definitely evaluated the situation. And this 700 odd, square meters is a separate land altogether. From day one, that is the understanding. And it was supposed to be vested with the government where the acquisition was supposed to be done, which has not been done, and it has reversed back to the owners. Now they are at liberty, they are the owners, they can do whatever they want to do with the, the land parcel. Since you had already in your first round of litigation alleged that this was also taken into consideration at the time of granting of the sanction, which has been turned down, you can't raise that point.
Again, I'll be bound by res judicata there because I am a person who's claiming through that title. Therefore, I'm hit by section 11. To that, my humble submission was that none of the honorable division benches, neither the learned single judge nor the honorable division bench, has decided this question. Therefore, the application...
You come back after that. You withdraw this writ petition when your right will accrue. You come back.
But my right to present it is in present time. Please see this. My right to present it is in present time. I am not hinging on title. I am not basing my right on title.
You are hinging on the sanction plan.
I'm
which has
attacking
already
the sanction plan.
Which has already been taken care of, sir.
it has, with great respect, my lord, it may not have been taken care of because neither the learned single judge nor the honorable division bench has pronounced on it. The honorable division bench missed dealing with
Single
that.
judge has already pronounced it in. You have gone to the DB had passed an order. Somehow you were not agree with, you were agree with the order. You took it to Supreme Court. Supreme Court gave you liberty to file a review. You have filed a review. Review is pending.
Review is pending here. Now, under such circumstances,
Today the issue has already been resolved by the single bench.
the single bench's order is tentative. Is tentative? Tentative.
Yes, till the time
That may not bind your lordship today. Had it been an
Today
absolute,
I can't pass any order.
then my lords, let me do this. That's why I was, my lord, in the beginning making this submission. Instead of taking it back and coming back again, I was humbly seeking this.
Today you don't have any, this petition is not maintainable. It is barred by res judicata. You don't have a right.
My lord, may I argue, my lord, on res judicata then? Only on that.
I know you can argue on all the points, but the fact is, it is not maintainable at all. It is not maintainable.
Because of that, yes.
Absolutely.
So, my lord, may I seek this? May I seek delistment until that happens? Otherwise, Lord, I am not claiming any order or seeking any order.
I will not keep it pending at all. I will give you the liberty to come whenever in accordance with law you have to come after the decision has been taken. But till then, I am not getting it. I am not getting. I am not putting my finger into this dispute. I'll dismiss it on the ground of maintainability. If you want me, I can do it.
No, maintainability would that would hurt.
That will hurt.
That would hurt.
And that's why I don't want to do anything. You better withdraw this writ
Kindly
petition.
grants me the liberty to refile.
In
on the
accordance with
self-same
law,
cause
you
of
have.
action.
I can't give you
Then
that. I will only tell you that you can file it in accordance with law.
Yes.
Liberty on same cause of action. I can't grant you that liberty.
No. Then, my lord, my right is finished under
No,
20.
your right is not finished. I'm not passing any orders on this. I'm only simply saying that you are withdrawing this writ petition with liberty to file any petition in accordance with law. That's all. I'm not expressing any opinion on anything.
Then, my lord, the non-grant of that liberty may be construed as an abandonment.
I'm not saying anything. I'm not passing any order in your favor or against.
Then, my lord, kindly record my submission and says withdrawn with the permission as paid for. No. Subject to law, in accordance with law.
In accordance with law, you already have the liberty whenever you want.
If I withdraw, unless your lordship specifically give me liberty, my lord, I will be hit by Order 23, Rule 1. I can't represent a cause of action.
You can. You can.
There will be a bit of doubt, and this is abandonment.
You can.
In that case, my lord,
you simply withdraw it. It's better for you. Why do you want adverse orders from me? That's my suggestion. I mean, for you to.
Can I get a day to mull over it and come back?
We are ready with our.
No, I mean,
I'm also ready.
Everyone's ready. Everyone's ready. That's why I am praying for it. That's why I'm praying for it. They just mull over it and come back in. No, that's all right. I've said. No, 8. No, there are 8 litigations, not the 8.
There are other judgments also, Mr. Mann.
I know you come up with very innovative arguments.
We have all the
This
judgments.
one, I think it's better you wait for the outcome of the review petition.
Please give me a day so that I take the decision as on instructions whether to withdraw it or not withdraw it. If I don't withdraw it, they suffer an order. It's up to them. It's the client's up.
We'll have it tomorrow, Mr. Ghosh.
Tomorrow.
Tomorrow.
কি বলবে কে ইনস্ট্রাকশন চাইছে কি করবে?
Learned counsel for the petitioner seeks a day's accommodation to take instruction whether he wishes to press the present writ petition, whether he wishes to withdraw the present writ petition. Let this matter be listed tomorrow.
I'll come back only on that point. I won't argue further. It's either A or B.
I'm obliged, my lord.
Better if you wait for the review
Yes. That's
order in the review.
All right.
obliged, your lordship.
110.
No suggestion, Mr. John.
Met with the order for the petition. All right, here's the affidavit of service. I have served upon all the respondents, including the private respondents.
This writ petition is preferred, my lord, alleging the unauthorized construction on behalf of the respondent number 7 to 10, who are the adjacent, my lord, landowners, where, my lord, the petitioner's old premise, my lord, is situated. So, my lord, the basic allegation, my lord, in the writ petition, my lord, that I have made, that they have been, my lord, raising this construction, the private respondents.
My lord,
My lord,
for the private response.
yes. So, my lord, without leaving the statutory site space, and also, my lord, without the sanction plan as well. My lord, without which, my lord, I have been informed that the sanction plan, a plan which is, my lord, has been, my lord, granted to these individuals, my lord, it is completely without the law, and that too, my lord, they have been, my lord, making the deviation from the sanction plan as well. So this is my instruction. But, my lord, what I see, that they have been, my lord, raising this construction, my lord, without leaving any such statutory site space, as required, my lord, under the 2007 rules. So, my lord, I have made this representation, my lord, to the municipality, which at page number 22, my lord, I'm sorry, my lord, it is in Bengali, my lord. So I was praying so that, my lord, they, the respondent municipality could, my lord, consider this representation upon hearing the parties. And also, my lord, I will be beseeching your lordship that after getting the copy of the writ petition, my lord, they have been, my lord, they have increased the speed of making this construction, the private respondent. So I'll be just beseeching your lordship till the decision is taken by the municipality, at least they should not raise anymore. This is my prayer.
This is the, yes, my lord, this is the property where all the brothers related, my lord. It is a divided property through court. Well, the problem is this, my lord, the common passage, which right now is in existence, if they want to use that as a path, then they create trouble. We are doing, it's a fact, but we are doing our patches work because it has long been
What,
done.
you're private respondent?
We are the private respondent.
Who's for the corporation?
My lord, I have served, my lord, they have received as well, the municipality.
Affidavit of service you have filed.
Yes, yes, yes.
Municipality
Tell them again, which municipality is this?
But
Which municipality?
appear করে মনে- কি বলবো?
Which municipality?
Own municipality.
But it is Dankuni municipality.
Dankuni.
है ना?
Who's the lawyer for Dankuni? हमारे पास है कोई नंबर है? Dankuni
My lord, I'm not sure. Ananda ki na ki. But I'm not, maybe, my lord, my learned senior friend, Mr. Oyan Banerjee.
Oh,
Please find out, serve them again, come back.
But till then, my lord, they should, my lord, resist their construction.
I'm not saying
They are not
anything.
doing
I'm
anything,
giving you
yes.
2 days.
If they are not
Mere
doing, well, can you
allegation,
record
my
this?
2 days.
My lord, after getting the copy of this writ petition, they have increased the speed. My lord, since it is
2
subbing,
days, how many bricks they can put? And we'll get it all demolished. Let them construct.
yes, well, if everything
Let
not as per law, he has to be
the entire
demolished.
thing
Has to
constructed.
be
Don't worry.
demolished.
as your lordship, please.
If it's illegal, it's illegal.
Yes, your lord.
As your lordship.
Affidavit of service is taken on record. Learned counsel, the petitioner is directed to serve upon the respondent afresh. Respondent number. Phone number?
My lord, it would be, my lord, respondent number 2 to respondent number 5.
Well, 7 to 10 is appeared before your lordship.
2 to 5, my lord, are the
2 to 5.
municipal authorities.
Afresh.
Chairman.
Let this matter be listed. Friday?
As your lordship.
You'll have it on Friday?
Yes,
On Friday.
Great.
Find out the lawyer, serve him by hand.
Grateful. I'll do this.
If
Well,
they don't,
28th.
and give me the service, serve them by hand. If they don't appear, then we'll pass.
Well, can you record private respondent appeared, my lord? Can you record that, my lord? We have the private respondent, we have appeared, my lord.
Give your appearance.
Yes, already had.
Done.
$124.
Your Lordship, this is a writ petition regarding an unauthorized construction for the third floor and the fourth floor. A representation has been made to the prior respondent number 326 on 6/2/2025. Still date, no action has been taken.
Which corporation?
Which corporation?
Kolkata. Where is this?
Kolkata Municipal Corporation.
Mr. Ghosh was here. Mr. Nayak, you appear for KMC. Take instruction.
How to appeal, Lordship?
Take instruction in this.
My lord.
The petitioner has preferred the present writ petition alleging unauthorized construction. And what is the DAG number?
Copy to your একটাই আছে দিয়ে দিচ্ছি Here কি আছে? Unauthorized construction demolition. WK নাম্বারটা দিবেন।
At premises number 12H/12/H/44 Bedford Lane, Calcutta. Who are you?
I'm the petitioner. I'm for the state.
Who are you? Where do you live?
At the same premises.
At the same
Premises, ground floor.
It is stated by the learned counsel petition that unauthorized construction has been carried out on the third and fourth floor of the aforesaid property. None appears on behalf of Calcutta Municipal Corporation. Full stop. Mr. Naik, who is present in the court, is requested to assist in this matter. Let his appointment be regularized. He seeks 2 weeks time. 1 week? Next.
Lordship, 1 week. 1 week.
1 week time to seek instruction. Let this matter be listed on.
Kindly get it, make observation that we are appearing in the matter along with my junior lordship.
Sorry?
I do appear in the matter, lordship, with one of my junior lordship. Because the instruction of what we already take.
Is appear Mr. Naik, who is present in the court, is asked to assist this court along with his junior, Mr.
Rituparna Moitra.
Rituparna Moitra. Let his appointment be regularized. He seeks 1 week time to seek instruction. Let this matter be listed on.
And a copy may kindly be given to me. Sorry, sir, this number. Grateful lordship. And a copy. Second. Second April লিখেন আপনার নাম্বারটা বলুন না আমি লস করে দিই না আপনার ফোন নাম্বারটা লিখেন
Item number 128.
আমাদের তো আমাদের May I resume? Yesterday I was trying to make out a point that I was a tenant in the property since 2004.
Correct.
There is a written agreement and the landlord have accepted my rent and they recognize me as a tenant. They entered into a development agreement. The development agreement speaks of the fact that there are multiple tenants. And that there will be from the tenants the necessary documents executed. Now, I can point out before your lordship the clauses in the development agreement which speaks about that fact if it is disputed. Now, the developer entered into a development agreement. The development agreement is a registered development agreement. Pursuant thereto, they applied for the sanction of the plan, and the sanction was obtained. And in the plan, there it shows there are certain shop rooms in front of the building abutting the main road. Now, I am not a shop owner in respect of the property, and as a tenant, I run a shop. Law requires that they have to take my consent if they want to take a leeway about the extra FAR. That is under 142(3) of the rule. It is my case that I complained before the corporation that even if they have availed of the particular the relaxation of the FAR, the extra FAR, there was no consent taken from my client, who is the recognized, not the tenant in the property. But I can hand over the book. But
building rules. Yes.
Calcutta Corporation building.
142 you read.
142
dilapidated or
3.
Whatever.
Yes.
Old and insecure.
Lordship. Every application for availing relaxation under sub-rule 1 has to be accompanied with the documentary evidence of the tenants of the existing building signifying their consent to the demolition thereof.
Right.
So, my lord, all that it says that, my lord, the application must be, my lord, with a documentary evidence of signifying demolition, consent of demolition, meaning thereby, my lord, the protection of the tenant is, my lord, assured here. Now, my lord, if they have availed of this in the sanction plan, they have to precede that with, my lord, this declaration from my client consenting to the demolition. We complained before the corporation to say that you have sanctioned the plan with that 142 relaxation in place, but my client had never consented to the. Therefore, you kindly revisit your sanction of the plan and kindly consider whether it is liable to be cancelled or not. It all emanated from the fact that, my lord, even after, my lord, the rebuilding of the property, I, as a recognized tenant, I have a right of, my lord, the restitution of the equal space, my lord, that I was occupying. That is under, my lord, the tenancy law. And, my lord, so far as, my lord, the Corporation Act is concerned, my lord, which I am, my lord, really aggrieved about, it requires, my lord, the tenant's consent before the demolition is concerned. That being not done, my lord, I have really assailed upon, my lord, the sanction of the building plan. Now, my lord, your lordship will kindly, my lord, come to, my lord, my representation at page 115. My representation is all about, my lord, what I have said.
Yes. The representation is?
At page 115, 150, 115.
अरे yes. Yes, sir.
Lordship. Now, my lord, my prayers are at page 30.
Yes. The sanction of 2019.
Lordship, it is a sanction of 2019. Lord, I could get the documents, Lord, from the Lord Webrera website. That is, Lord, a website that the developer nowadays, Lord, they have to mandatorily upload. And from there, I could download, Lord, the sanction plan and get the particulars thereof. But that I have stated in my, Lord, the petition, Lord, the relevant paragraph is paragraph 10 at page 23. Paragraph 9 also, Lord, at page 23.
Yes.
Now, Lord, in this context, Lord, I'll be relying upon a single bench decision, Lord, which is reported in 2017 SCC Online 8262, Lord, paragraph 8, Lord, in the context of, Lord, Rule 142. 8262, 8262. Lord, paragraph 8. 2017 SCC Online Cal 8262, paragraph 8.
Which para? 8.
Paragraph 8. অন্য জায়গায় লক করেছি এটা টার্মিনেট হয়ে এই দুটোতে হয় না সে কি করছিস Yes. Similar, it is paragraph kota? 580. Now, my lord, another judgment, my lord, 2017, volume 4, CHN, page 6. But the paragraphs are, my lord, 5. 2017, volume 4, CHN, page 6. It is the Bengal Bonded Warehouse Association. Paragraph 5, 18 and 20. This is a division bench. Five 18 and 20. You have assistance. You look good, must be not here giving any brief to this. You will lose this. So you have a Corona caster procedure exams. 5, 8 and 20, 18 and 20. I'm sorry. টাইম নিতে হবে এছাড়া তো উপায় নেই আমি তো এখানে পাশাপাশি দিতে পারবো যে অন লেগস বলে This is on Lord. Why Lord on the basis of a suppression, a plan has to be cancelled or liable to be cancelled. Paragraph 18 about Lord the last 4 lines. Yes. So, Lord, it is not that, Lord, that I have to be heard prior to, Lord, the sanction is being granted. But it is all that is necessary that if you want to avail of the relaxation, you have to have, Lord, my consent, Lord, on record. But that is all for my submission. Yes, Mr. Mukherjee.
Yes, my lord, very short point. My lord, my learned friends, my lord, entire writ petition.
Who appears for the corporation here? You appear for the corporation?
Corporation, I beg to.
So the sanction which you have granted, have you taken 142(3) into, you have given the advantage of the FAR?
No, that details from me, but the report what I have received is.
Sir, this is very important because this is the crux of the matter. If you have given them the benefit of the FAR, then this needs to be looked into. If you have not, then there's no problem.
My lord, I have the sanction plan. I will show your lordship. No benefit has been obtained, my lord, of the FIR under Rule 142.
But that cannot be, Lord, that is not explicit from the sanction plan. That has to be
handed up, my lord.
From the corporation can only say about that.
It's annexed to the writ petition as well. They have, my lord, annexed the building permit.
Sure.
My lord,
let us see.
My lord.
My report said very clearly that Lord has got according to that has been sanctioned. Number is also there. It is also there mentioned. And secondly, there are no unauthorized construction going on. We have Lord noticed after inspection it is determined by how decided by us.
Yes, Mr.
Yes.
Let me see.
Yes, my lord. May I show your lordship 2 things, my lord?
Yes.
Just 2 things. Your lordship's in the press. I don't want to trouble your lordship. kindly come to the representation, my lord, which is, my lord, at page
115. 115.
115. My lord, kindly come straight away, my lord, to paragraph 8. My lord, which is at page 118.
Yes.
My client had obtained a copy of the aforesaid sanctioned building plan, which has been sanctioned by a good office, thereby granting building permit to the landowners, etc., where my client is still in possession and is carrying on. It appears from the said sanctioned building plan that landlord and other co-owners so-and-so have kept provision for shop rooms indicated in sanction so as to avail the relaxation provided under Rule 142 without executing any agreement. Then, my lord, client reasonably apprehends, since sanctioned building plan which was obtained without had expired while the construction, your good office has extended without verifying so and so. So, my lord, there is space kept for, my lord, shop owners. So the apprehension is that, my lord, the relaxation has been obtained, and, my lord, this has been obtained without the consent, my lord, of the tenants. My lord, that's the only place where, my lord, the consent is required. They've had a look at the sanction plan. Kindly come to, my lord, the building permit. My lord, I don't think, my lord, your lordship can read from there. So, my lord, I have, my lord, because they've looked at it. Now, my lord, kindly have a look, my lord, at, my lord, the sanction plan. Forget the mark, show the most. My lord, kindly look at the column, my lord, on the right hand side.
Yes.
Just above, my lord, the big block which says proposed BNG plus 22 story at the bottom towards the second half, my lord. My lord, the bigger block. It starts from the bottom. It will find, my lord, the first block from the bottom is my lord, right hand side bottom. My lord,
Yes.
My lord, the first block is declaration of owners. Lordship has that, my lord?
Yes.
Now, my lord, kindly go up, my lord. Declaration of structural engineer. My lord, same. My lord, on the right hand side. Then, my lord, proposed PNG. Lordship has that plus 22 story. Now, my lord, just above that, kindly see, my lord, the long block 25, item 25, field 25, my lord, relaxation of authority of any. Lordship has that, my lord?
Yes.
Now, kindly see, relaxation is under what? Additional FAR for metro corridor within 500 meters and means of access greater than 25 equal to 20% extra under Rule 69A 1C. Kindly have a look at, my lord. This is, my lord, the additional FAR has been claimed, my lord, under Rule 69, my lord, A1C. And this is what they have annexed, my lord, this first page. They are aware that there is, my lord, no, my lord, now kindly have a look at the rules, my lord. There's no other, my lord, relaxation.
Mr. Mukherjee, what is the difficulty if their representation is decided by the court?
No, I have no problem, my lord, apropos. All that I'm showing your lordship, my lord, that this is, my lord, really, my lord, my lord, not a writ, my lord, in good faith. They come with a case of 142.3. My lord, there is no 142.3 relaxation which has been on the face of it. And, my lord, number two, which your lordships must know, my lord, that these are, my lord, all, my lord, RERA, my lord, registered projects. Now, my lord, this is a 22-story project. 17 stories are over. And, my lord, they've done nothing. When, my lord, the plan, my lord, has been extended is when they make, my lord, the representation to the corporation.
No, I can ask the corporation to decide the representation in the time.
Yes, my lord, but I'm showing your lordship straight away, my lord, this will.
I can.
Because this is, my lord, I have no problem, my lord, to the corporation, my lord, disposing of the representation. But my lord, on the face of it, my lord, I am showing your lordships, my lord, that relaxation was never obtained. My lord, by my lord.
Decide, Mr. Naik.
And my lord, one other thing, I mean, my learned friends probably aware of it. My lord, dead persons have also been made parties. Dead persons.
The landlords, I can name the landlords.
Please.
I will take another section 412A of the corporation. Capital A.
You also give me the order of 16/12/2024.
My lord, I gave that order. My lord.
Yes, I have that.
Yes.
Wait, what are you showing?
Section 412 capital A.
400.
12 capital A. Power to declare building or any part thereof condemned and to order demolition of such building. Notwithstanding if the content, contrary content is this act or in any other law of the dynamic force or etc., where it appears to the corporation, municipal commissioner, that demolition of a dangerous building under section 411 will cause hardship to the persons in occupation of such building and may not be conducive to public interest of the area. Suffering from active shortage of accommodation will be open to the municipal commissioner to proceed in the manner and take steps as set out herein. Even first, my lord, a declaration has to be made that this building has to be demolished. My lord, once this declaration is made by the corporation, it has to be pasted. But the time to take, my lord, only
This is not a case of 212A, Lord. They have applied for a sanction building plan.
So 412A, because the condition precedent for allocating additional floor area, my lord, is the relevant statutory provision.
So that will be, sir, that will be thrown out if they have not taken the additional FAR. That issue is already over.
Because
There's no problem. Let them answer. See, this court can't answer that question. The corporation.
Correct, my lord, the statutory authority should.
Yeah, they should.
So, my lord, that's why I said I have no objection. But my lord, kindly note that I produced this sanction plan also. That's all.
Provisions are like if this has happened, if that
In
has
fact, my
happened,
lord,
if that has happened.
the building permit they have annexed
Take down.
shows, my lord, the relaxation is only.
The present writ petition.
My lord, may I have your lordship's kind leave,
Yes,
my lord?
yes. In the present writ petition, the petitioner is challenging the inaction on part of the respondent municipality in not cancelling the building permit being number 2019100143 dated 17th December 2019, granted in favor of respondent number 6 for constructing the multi-storied building including commercial complexes at premises number 11 Deshpran Shashmal Road, Police Station Charu Market, Ward number 89, Borough number 10, Kolkata 700033. Full stop. According to the learned counsel for the petitioner, the respondent number 6 has availed the benefits under Rule 142(3) of the Calcutta Municipal Building Rules 2009 without taking the consent of the office tenant.
Lordship.
Full stop. It is the case of the petitioner that he was inducted into the premises as a tenant by virtue of a tenancy agreement dated 26th March 2004, and he was running his business therefrom under the name and style of just what is this?
Raipur Electronics.
Raipur
RAIPUR.
Electronics. Full stop. The landlord of the registered development agreement dated the landlord of the petitioner along with other owners have jointly executed a registered development agreement dated, what is the date of that agreement?
It is
7/7/2023, ma'am.
7/7/2023.
23, ma'am.
23. 23.
Yes, ma'am.
With respondent number 6 for purpose of developing the said premises by constructing thereupon multi-storied building, including commercial complex in the including commercial complex, full stop.
So I think it is 2013.
2013, it can't be
13.
23, sir. 19 is the sanction plan.
Page 49.
2013. It is the contention of the, it is the contention of the learned counsel of the petitioner that the said development agreement mentions about several tenants in the said building. The said agreement further stipulates that after completion of the multi-storied building, the existing tenants will be rehabilitated as per clause 8.7 of the development agreement. 8.7, right?
8.7. Lord, I'll just check. Mitro, একটু assist কর।
Yes, ma'am.
তো মাথায়
8.7.
অন্য কিছু ভাবছিস।
8.7.
8.7. As per clause
Lord.
12.3, the owner shall obtain no objection certificate, no objection from the
8.7.
tenant slash occupier for construction of the building before submitting the plan to the Calcutta Municipal Corporation. Full stop. It is the case of the petitioner that no agreement was entered. He had not entered into any agreement with the landlord or the developer for securing his rights as a tenant. Full stop. The respondent number 6 obtained the sanctioned building permit dated 17/12/2019 for raising D plus G plus 22 storied residential building and single storied mercantile building at the premises in question. It is the contention of the learned counsel for the petitioner that the respondent number 6 obtained the said permission in violation of section 142(3) of the Calcutta Building Rules 2009. Learned counsel for the petitioner submits that he had preferred a suit for declaration and injunction against the landlord before the additional civil judge, Junior Division 3rd Court at Alipur, full stop. He had failed to obtain any interim order in his favor. Thereafter, he filed miscellaneous application, miscellaneous appeal number. Miscellaneous appeal number, what is it, Mr. Gupta?
Miscellaneous appeal number. Miscellaneous appeal number 92 of 2023.
92 of 2023 before the
There was an ad interim order there.
District Judge Alipur, and by order dated 1/4/2023, the learned District Judge was pleased to pass an interim order of injunction, thereby restraining the landlord and the developer from evicting the petitioner from the premises in question till 2/5/2023. Full stop. Learned counsel for the private respondent has handed over a copy of the order dated 16/12/2024 and submits that the interim order is no longer in force in favor of the petitioner. Learned counsel for the respondent municipality submits that the petitioner, through his advocate, has submitted a representation dated 25/1/2024, raising his grievances, and the same are pending with the respondent authorities. The respondent authorities are ready and willing to consider the said representation of the petitioner in a time-bound manner, preferably within a period of 2 weeks. 2 weeks after granting an opportunity of, or within 4 weeks after granting an opportunity of personal hearing to the petitioner as well as the interested parties, including the respondents herein. Full stop. From the date of communication of this order. There's no in learned counsel petitioner as well as the private respondent agree to such course of action. Full stop. In view thereof, the present writ petition is disposed of with the direction to the respondent municipality to consider the representation corporation to consider the representation of the petitioner dated 25/1/2024 within a period of 6 weeks, 4 weeks, 4 weeks, 4 weeks from the date of passing this order by way of a speaking order after affording an opportunity of hearing to the petitioner as well as the respondent and any other interested party. I'm grateful.
7 or 8 persons who have been named as party respondents, they are dead.
There must be a representation of the owner's side. That doesn't mean that each of the owners, my condolences, but still there are certain owners
I
left.
accept the condolences, but my lord, I accepting condolences will not cure the defect.
So
But if my learned, I'm sorry.
What do you want, sir?
My lord, they have to be named and notices are to be sent to them also.
Lord, they know who are the illegal heirs. I do not know. Lord, I am a third person. He knows, Lord, Order 22, Rule 10A. That requires him to intimate.
Don't write respondent.
He has not discharged his duty and blaming me.
As well as interested party.
Dismissed on that account only. That the misappearance to rebate it. That is the.
But my learned friend, Lord, lets me, Lord, know about the legal heirs, their address, Lord, I'll certainly, Lord, let them know.
We will do.
But kindly record their undertaking to that effect.
What do you
That he will intimate.
He has filed a petition, the tenant. My lord, the tenant wants the tenant wants me to give an undertaking that I will provide.
Under Order 22, Rule 10A, if he is appearing for those parties, he has an obligation to intimate.
I am appearing for those parties. It is my duty to inform that.
Then, Lord, he is, Lord, appearing for the owner's side.
address the court, please?
My humble submission would be to lordship is that at least 8 persons have done.
Yes.
Who have been named as party respondents.
Right.
I am not representing those parties. It is my duty to inform your lordship that these persons have died. They have been named added as respondents in this particular petition.
Who are the people who have died?
10, 14.
Just
Click.
Otherwise, a lot of participants.
It's all representative capacity, it can be done. The owners, 44 owners, they don't speak differently.
Learned counsel for the corporation, the municipality submits that the lawyers for the parties shall be intimated in and that should be assumed as proper service to the respondents.
I'm grateful.
If the details of the respondents were
Learned counsel for the respond number, you are?
Respondent.
You are appearing for who are you are appearing
7, 8, 37. I am appearing for 7, 8, 37, 38.
And who are
10, 14, 18, 28, 29, 43.
learned counsel for the respondent who are the respond number 7, 8, 37 and 38 states that respond number 10, 14, 18, 28, 29 and 43 have deceased. Is it true?
But I do not know, Lord, it is their claim.
If you have made them party, Mr. Mukherjee.
I have got, Lord, their names from, Lord, the website of RERA where their names figure as, Lord, the owners. So it is my learned friend, Lord, who says, therefore, Lord, he has to.
I'm trying to find a solution.
But
If you want me to give you a date, 4 weeks, 6 weeks, 8 weeks, 10 weeks, I can do that. You want that, I can.
But I can do one thing. Lord, your lordship may, Lord, delete the names of this person because, Lord, the owners are represented. One owner will not suffice here. I'm not going into those. Otherwise, my learned friend is to give me the particulars for
Mr.
substitution.
Mukherjee fairly concedes that the respond number 10, 14, 18, 28, 29 and 43 shall be deleted from the array of parties. With the above direction, the present writ petition is disposed.
Lords, I'm grateful. I'm grateful.
One more redundant process. So 4 weeks, that may 8 weeks.
8 weeks. Let it be 8 weeks. There are a lot of problems. 8 weeks.
I'm grateful, Lord.
But is it that, Lord, we need to, Lord, score out the names of, Lord, the deceased person, or, Lord, by judicial order, that is?
Just score
Well,
out them.
Lord, then I'll, Lord.
Yes.
Then
Necessary
your Lordship
correction.
grants leave, Lord, to
Liberty
correct,
is
Lord.
granted to the petitioner to make the necessary correction in
Lordship.
the array of parties.
Lordship. I'm grateful.
This is my petition. My lord, unauthorized and illegal construction. The petitioner is the the respondent is the adjacent plot holder. There is 6 feet wide road. Showing that 6 feet wide road, 10 feet, obtained a 3-storied building plan and constructed, just befooling the authority. On the and as to the illegal part, my lord, upon septic tank, 3-storied construction has
Who
been
are
made.
you?
I'm the contiguous plot holder.
Contiguous plot. Your construction is legal?
My construction, some part has been found illegal by the municipal authority in another proceeding.
They have demolished it?
They have given me time, 3 months time.
3 months time for what? For to carry out demolition on your own?
My lord, I have already carry on. There are some flaws in the order that my building, my land is 1 kata 8 chitak. The municipal authority, the measurement has been made. There it is that shows that it is 1 kata 5 chitak. There are encroachment, etc. Perhaps my client will go to the civil court. But here the cause of action is completely different.
There's an order of demolition against you. Who appears for the corporation?
Lord, sir, I am for the Rajpushan for municipality.
Why you
Lord,
have
sir.
not taken action against him?
No, Lord, sir, the order has been passed and this is the order, Lord, sir,
Order passed against whom?
against the petitioner, Lord,
Why you
sir.
have not taken? When did
No, Lord, sir.
when did you pass the demolition order?
Lord, sir, that was passed.
Sir, 2 days before, just a couple of days before.
When are you taking action?
No, Lord, sir, that is 26th February 2024.
We are
Lord, sir,
sitting
that
in
was
March.
19th.
Just 2 days before it
Lord,
has
sir,
been served.
19th February 2025. Lord, sir, reason order has been passed. Lord, sir.
When are you taking action?
Lord, sir,
They have
they have
taken action.
passed reason order and they have been directed to demolish as per the sketch map. If they not demolish, municipality will
How
demolish.
much time have you given them?
90 days.
Lord, sir, there is 3 months time. Lord, sir.
3 months you give to demolish.
Lord, sir,
What
at
does
their
your
own.
act say? After the passing of the demolition order, how much time are you supposed to give?
Lord, if they considering the parties, it is hereby ordered the private respondents to take immediate steps to alter and to remove the structure of the building which has been raised in violation of the sanctioned building plan number such and such, as shown in the annex 4 pages demolition sketch map prepared by the concerned engineer within 3 months from the date of receipt of the order.
How much time is it prescribed?
So
in the act?
as to the
Wait, sir, am I asking you?
Within 3 months from the date of
Sir,
receipt.
where do you get this 3 months from? Show the law. How much time? Once a demolition order is passed, when are you supposed to demolish? How much time?
Hmm.
30 days. There is also civil recourse under the statute, my lord. If one is not satisfied with the order passed, demolition order passed by the municipality concerned, under the statute, there is provision for civil recourse.
Wait, sir.
A petitioner made representation 2 years back in 2023.
দুশো আঠারোতে নেই, কিছু নেই।
30 নেই?
না না, দুশো আঠারোতে নেই। নেই নেই, এখানে নেই। আরে কর্পোরেশনে আছে, মিউনিসিপ্যালিটি অ্যাক্টে নেই। আচ্ছা, বলছি নেই, নেই।
218 subclass 4 এ বোধহয় appeal টা।
না না, অ্যাপিল আছে, ইয়ে নেই।
Appeal টা আছে। Before
There is no provision.
214 subclass 4. Also, বলতে হবে।
So they are supposed to file an appeal within 30 days. You are supposed to
Lordship.
take, you read section 400. Read section 400.
Lordship, it is the West Bengal Municipal Act, Lordship.
There must be a parameteria section there also.
Lordship, for demolition, Lordship, that is 218.
218.
Three. And subsection 3 and appeal, Lordship.
400.
18 or 218, Lordship.
218, section 218.
280.
218. Yes. And subsection 3 is the provision for appeal.
This is ground on sanction can be refused.
No, sir, 218, 218.
Is prohibition of West Bengal Corporation Act, right?
No.
No, no, Municipal Act.
Municipal Corporation Act.
No,
No,
not
no, no, no.
corporation. West
Municipal
Bengal
Act,
Municipal-
1993.
1993. This is the
Corporation
parent
Act,
act.
another act, Lords.
This is the parent act, my lord. দাও না, তুমিটা দিয়ে দাও।
ওটা দিলে আমি কিছু বলতে পারবো না। তুমি পিটিশনের তুমি বই আনো নি, কি হবে?
এটা জিজ্ঞাসা করবো বুঝলি?
টাইম বলা নেই। No time frame.
Take action on his property also. The petitioner has preferred the present writ petition. The petitioner has preferred the present writ petition alleging unauthorized construction.
And illegal also.
Unauthorized and illegal construction
Of respondent number 5 and 6.
by respondent number 5,
4 and 5.
4 and 5. At premises number, what is
No
the
premise number is given there in the holding number. Holding number, there is no specific holding number available here in this writ petition. Actually, Ghashiara B. Road name Ghashiara B.
holding number.
Holding number. Private respondent is present too. We think perhaps the holding number
You are
is.
the private respondent.
My lord.
What is the premise number?
Holding number.
Holding number. A representation is there.
My lord, kindly see the, my lord, pair of the writ petition.
I can see
Here
that.
have no, my lord, regarding any, my lord. Kindly see, my lord, first, my lord,
You give me the address at premises number. What is the address?
Address has been given, but the
What is the address?
Here, my lord, in the representation, holding number 132.
no, that is my my holding
What
number.
is your building where the construction has been carried out?
My lord, their representation, their made representation, my lord.
I'm asking you, what is your building address?
Regarding address, I take instruction. I take instruction.
What do you mean you take instruction?
Because, my lord, today, my lord, my lord, kindly see their representation.
Today you are here for what? Defend your construction. Where is the construction taking place?
My lord,
Give the address.
my lord, I'm pardon. My lord, I have planned it.
Holding number to know.
My lord, my holding number, my lord, tag number 505.
Dog number 505.
Holding number.
Holding number 312.
Holding number 31.
312.
Ghashiara B.
Road number,
Road name of the Ghashiara B.
What is the place?
Milord, the private showing road.
Why you have not put one more word? The writ petition is dismissed for not putting not putting the necessary building number.
Milord, constant my
necessary
Milord,
particulars,
constant. Milord, constant sees the constant.
Take it in appeal.
Milord, constant sees that he is residing just behind me. How can I know? They are in the Sonarpur.
Don't know. I will not entertain the writ petition.
Milord,
Where have you given the address?
No, your lordship will find
Where have
the
you given the address? Where is the address? Show me the
address has been given in the cost title.
Where is the address?
Yes, cost title. Cost title. Page 3. The address of the petitioner is given. They are residing there.
Ghashiara.
Ghashiara.
How big is Ghashiara?
How
big is Ghashiara?
Ghashiara is a Mauja.
So Mauja is the area.
Milord, Milord, also the Dag number is given. Dag number is here.
Where is it?
Okay, that is in my. I'm showing Milord.
You file a better petition.
Milord,
Dag number petition. You file a better petition.
Milord, that has been holding number has been
File
provided
a
by the
petition with better particulars. Learned counsel of the petitioner seeks to withdraw the present writ petition with liberty to file the writ petition with better particulars.
Holding number. Milord,
File a better petition.
Milord, my constant.
File a better petition. Sir. Liberty is granted. The present writ petition is dismissed.
Sir, আমার হোল্ডিং নাম্বার 312 আপনি এখানে লিখেছেন 1324
312
312 হোল্ডিং নাম্বার আপনার রিপ্রেজেন্টেশনে 1324
তুমি বলো না
আমার হোল্ডিং নাম্বার
keep quiet. Next.
130. I am for this.
My lord, I am behalf of the KMC. I am praying for not today, my lord.
Not today. Calcutta.
131. But I have got a private respondent. But one thing, the petitioner is not appearing, that I know. One thing, perhaps it is required to be translated. Because so many representations and all those things are there in vernacular language.
Bangla.
Bangla.
I can read it.
Oh, then it's okay.
I can't read it, but I can understand. So some person can read it, I can understand. What is it? He's raising unauthorized construction or what? What is he alleging?
One of the allegation against me is that I am running a beef shop.
You're running a beef shop.
Beef shop.
You're running it or not running it? You have a license, trade license?
Trade license. I'll produce that.
We'll see. And for the petitioner? Not.
But I beg apology. I had no knowledge. Beef shop.
132.
My lord, this is a case of unauthorized and illegal construction by the respondent number 5 to 9.
Yes. Where's Mr.
My lord, he is engaged in court number 6.
Mr. Sandeepan Banerjee is not here. We'll have it tomorrow. Tomorrow?
Lordship, I don't have
Not
to
today.
brief, Lordship.
Tomorrow.
You not say kindly pass a short order.
Why? You get paid by orders. That's only for the department, I believe. Petitioner also. What short order you want? What short order you want? Give it, give it.
I am appearing before your lordship.
Mr. Banerjee, these days even private clients, they want short orders. Even the private clients, lawyers for the private client, they want short orders, like the state.
In this case, I have instructions regarding this 32.
Yes.
They have constructed on the basis of permission, not on the basis of any plan. And even then also they have constructed beyond the permission. The inspection has been done yesterday. Further inspection required to be done.
So take action.
I will take it.
The petitioner has preferred the present writ petition alleging illegal unauthorized construction carried out at. Who are you, but? Who are you?
Petitioner. I am the petitioner.
I know you are the petitioner, sir. Where do you live? Where do you live? What is your problem with this person?
The person is making unauthorized construction at the 4-story building after demolishing the 2-story structure.
In this city, there are thousands of people who are doing unauthorized construction. What is your problem with him? You tell me that.
I am residing at the adjacent premises. The building may be collapsed at
That's what I'm asking you. Mr. Banerjee.
Yes, sir.
He's the next door neighbor. He loves his neighbor too much. What about his property?
His property has also been complained of.
Demolish both the property.
Yes, yes. Because his property has also been complained of.
My 2-story building, I have already regularized and penalty has been given before the municipal authority.
That I have to take instructions, but let the matter be taken up after matter. Sometime I will take instructions regarding both the property.
Legality in his building, take action.
As your lordship.
Preferred, क्या लिखा है? Unauthorized construction carried out premises number 52, Pilkhana, 1st Street, PS, Golabari, District Havra, at the instance of respondent number 5 to 9. Counsel for the respondent, Mr. Sandeepan Banerjee, counsel for the respondent municipality. The work stop notice has already been issued.
Already been issued.
Issued states that a work stop notice dated 24/1/2025 under section 177 of the Havra Municipal Corporation Act has been issued. Full stop. He seeks further time of, how much time?
3 weeks.
3 weeks time to file a detailed report regarding the unauthorized construction. Let this matter be listed after 4 weeks.
4 weeks.
Grateful.
5 star.
3 weeks. 3 weeks.
Sir, 130 হ্যাঁ লিখে দিচ্ছি 133 ব্রিফ নেই আমাদের কাছে।
বলে দিচ্ছি। 133 আপনি ব্রিফ দিন।
Yes, what are you doing here?
কপি তো কর্পোরেশন দিয়েছে। একটা কপি দিন আমাকে।
That's why I asked you, what are you doing here?
Mutation.
133.
Here I
but I
can
am
see
for the-
different faces.
Petition করেছি আর prescribed form.
প্রেসের ফর্মে করেছেন?
হ্যাঁ। Well, in this one, I am for the petition. Well, I have purchased a property, my lord. I made an application for mutation in the prescribed form. I also made a replacement. Well, consider that part only.
He's seeking mutation.
Mutation.
Regarding mutation, madam, but a copy may be given to me
Well,
so that I can be.
I've already
prepared
served,
and-
my lord. I'm giving.
Yes, they have served on the authority, but if
Give him a copy.
Right now. Give it.
Let him take instruction.
একটা কপি দিয়ে দিন আমি করে দেবো এটা। আপনার মিউটেশন অর্ডার হয়ে যাবে।
The
ফটফট করে-
petitioner,
আরে আমারই তো দুটো অ্যাপিয়ারেন্স হবে, আমি চিন্তা করছি না।
petitioner has referred the present writ petition
ঠিক আছে।
seeking mutation of property number 31/1. Girish Ghoshal,
34 না?
PS,
এই একে কপি।
Mali Panchghara, Havra. Indian. It is the case of the petitioner that they had inherited the property in question from their predecessor. They had applied for mutation,
কোনো কেউ নেই ওখানে।
however, despite regular follow-ups, the respondents have failed to mutate the property in their name. Full stop. Learned counsel for the Mr. Sandeepan
yes,
Banerjee
yes.
appears for the respondent corporation and seeks how much time?
3 weeks, madam.
3 weeks time to file his affidavit in opposition. A reply to the same within 2 weeks thereafter, list after 5 weeks.
বলে দেবো সেদিন। আপনি কপি দিন আমাকে, কপি দিন।
এই দেবো।
এটা
Item 134. Lord, I am for the petitioner, my lord, the affidavit of service. Lord, kindly see, my lord, my predicament, my lord, I am running pillar to post, my lord, this, my affidavit of service. If your lordship takes up, my lord, the first order of the coordinate bench alleging unauthorized construction, I filed a writ petition, my lord, page 18 of my lord's brief. Has your lord?
Page 18.
Page 18, my lord, the first order of your lordship's, my lord, coordinate bench. But if I take your lordship,
Interstate dispute between the parties also, huh?
Yes. This was the tenor of the order, Milord. There has been restraint, Milord, from making any construction. What happened, Milord, in 2010, as per them, there was a Milord, ground floor construction. They have reconstructed 11 pillar and thereafter two 13 pillar and thereafter 2 additional floors have been constructed without any sanction plan. Milord, pursuant to this order, if your lordship takes up, the inspection took place. Milord, if your lordship takes up page 25 once. Page 25 of my lord's brief. Milord, the inspection report suggests, Milord, the 2 additional floor is without any sanction. The old construction is of the ground floor. Milord, the entire thing is being recorded in the inspection report.
Yes.
But thereafter, if your lordship turns over the page, my lord, to page 27 once. This is the demolition order passed way back on 22nd of January 2024. Pursuant to that, my lord, the report relied upon, my lord, and thereafter, my lord, it was directed within 15 days. If the person responsible is not, my lord, demolished, then the corporation, my lord, I shall show before your lordship the provision of section 177. The self-demolition notice, if not adhered to by the person responsible, then the corporation is duty bound to implement that.
Yes.
Now, my lord, if your lordship takes up, my lord, thereafter I again had to approach this honorable court. If your lordship takes up now, prior to that, once page 34. The second order, my lord, I shall show before your lordship. Page 34 is one of the RTI reply I have got, my lord, from the State Public Information Officer of the OSD, my lord, Howrah Municipal Corporation, wherefrom it has been revealed that last 20 years there was no sanction building plan in respect of that holding.
That they have already passed an order.
My lord, kindly takes up now page 35. Kindly takes up now page 35. I, Lord, filed the second round of litigation asking for implementation of that order. Lord, this honorable court passed that. Directed the Howrah Municipal Corporation to implement the self-demolition notice, which was, Lord, served way back in January 2024. Till date, Lord, nothing has been done.
File a contempt.
Lord, your lordship knows, my lord, second writ petition for implementation, there is always, my lord, your lordship's court has made it, my lord, very clear that it's not, that is the punitive jurisdiction, your lordship knows. The punitive jurisdiction, I am not interested to. What they have done in respect of my, my lord, partition wall, they have erected, my lord, entirety of 2 additional floor. I am the next door neighbor. My lord, there is a, my lord.
Who says it's only punitive?
Your lordship knows but your lordship has made it clear that for second writ petition for implementation, there is always
private dispute between
my
both the
learned friend
parties.
always say it is a private dispute
because their building are also at stake. My lord,
Mr. Banerjee is so much interested to save them. Lord, I must be candid. There is a revenge litigation. There is a revenge litigation. Thereafter, they have stated my building is unauthorized. I have shown
and
my
already
75
inspection
sanction.
has been done in their building. We will
Everything,
take steps.
everything done, Milord, in respect of
আমাদেরও
my
বলতে
building.
দিন, নাহলে আপনি বলুন,
Mr. Banerjee is supporting, Milord, them to such an
I am
extent.
not supporting anyone.
He is interested, Milord, in my.
Don't make that up.
আপনি চিৎকার করলে তো আমি বলতে পারবো
In
না।
my writ petition, he is asking that yes, my building is illegal.
Don't make allegations against a lawyer.
Milord, I am not. I am not. I am Milord, Mr. Banerjee. Milord, it's for his client, not against him. Milord, it is always for against his client. Not Milord, personally, I don't have Milord. We
are making allegation now. They say it is more for his client.
No, obviously, Milord, standing for Howrah Municipal Corporation.
Not in my court.
Milord, in my writ petition, Mr. Banerjee is saying my building is also
They know
unauthorized.
very well when I support them.
Mr. Banerjee, take action. What
Action against both. I will take.
Yes, action against both.
Milord, in respect of my Milord building, they have already inspected.
Inspection has been done in their case also.
Is agreed by the
I have shown the sanction building plan.
inaction on part of the respondent municipality in not carrying out the demolition action for premises number 20/2 Umesh Banerjee Lane, Shibpur, Howrah. Learned counsel for the petition states that
Milord,
despite an order of demolition being
the
passed
holding
on
number, Milord,
2024.
holding number should have been 21/3/B. That was corrected. That order was correct.
21/3
3/B.
Umesh Banerjee Lane. I
Yes.
just got it from this order.
No, Milord, that is Milord subsequently corrected.
उसके बाद क्या लिखा है? Despite an order of demolition being passed on 22/1/2024, counsel for the petitioner alleges that no action has been taken. Full stop. It is the case of the petitioner that she is the co-owner of the property.
No, Milord, I am not the co-owner.
You're not.
I am the neighbor.
She's the neighbor. She's the neighbor and had filed various complaints with the respondent authorities against the illegal unauthorized construction. Full stop. It is also stated that she had filed 2 writ petitions, WPA number 21601 of 2023 and 8497 of 2024. Full stop. Finally, but till date, no action has been taken. Full stop. Learned counsel for the respondent, Mr. Sandeepan Banerjee appears for the respondent municipality and states that and seeks 2 weeks time to file his affidavit in opposition. 1 week.
Affidavit in the form of report, my lord. Report, your lordship,
Affidavit in the form of report.
report, yes,
File a report.
stating the status.
File a report.
I will file. I will definitely file.
Just after 2 weeks.
Great. Also
Extremely
in this holding, I will file the report.
Yes, yes, my lord. In respect of my holding, I have shown the building plan. I will not shy away from your lordship's court. If I have certain wrong, my lord, your lordship will adjudicate that also. Great.
Rest of the matters tomorrow.
Grateful, man.
Tomorrow.